Let's see here. Hello. Yes, please. Item number 6, my lord. Yes, my lord, there is no communication with the client, my lord, since 2014, my lord. I tried to contact him, but could not connect, my lord. Ultimately, I sent a notice by registered post. It's a criminal appeal. You are there. My records are not available, entire records are with me, my lord. You see the court's records then? I sent a registered post notice, my lord. Court records are there. I sent a paper book. No, there is no paper book. PCR is there, na? You have a look today. Any other death metal arrested? All right. I can accommodate you till Tuesday, but not further than that. So you have a look at it. You make your notes. We'll have it on Tuesday. After 2 weeks, my lord. No, Tuesday is a 2014 appeal. Your name? My JP Chauhan, my lord. Mr. JP Chauhan, learned counsel for the appellant, submits that the brief of the appeal has been misplaced and is being unable to contact his client as the matter pertains to the year 2014. He further submits that though he has tried to communicate with the client through registered post letter, however, there is no response. Be that as it may, the appeal is a statutory appeal, and Mr. Chauhan is the advocate on record. The case records are available in the court. During court hours, Mr. So-and-so is permitted to go through the case records. The matter shall be taken up for hearing on Tuesday, such and such date. Can it be 20 Thursday? All right.
May I present similar prayer, Lordship, we are able to contact.
And you have a look at it. Registry may, on an application being made, furnish necessary copies of the appeal memo to the learned counsel upon paying the requisite fee. Yes.
Similar prayer, Lordship, we are not able to contact with the client, Your Lordship, and moreover, the counsel who engaged, he also.
Those are not material. It's a criminal appeal.
Yes, Your Lordship.
Which one? Item number?
Number 4, Your Lordship.
Item number 4. You are on record.
Yes, Your Lordship.
Then you are do it.
But Your Lordship.
What communication you need from your client? These are statutory appeals.
Your Lordship,
You must be happy that you're getting a chance to assist the court. You argue.
Yes, sir. But
If you don't want to argue, there are so many advocates in the courtrooms who would be willing to assist the criminal appeals. I can see Mr. Pankaj there. I'm sure he will.
But Your Lordship, the client is alive or expired, Your Lordship, that also we don't know.
But it's material. What information you need about all this?
2 weeks, Your Lordship, we will try to communicate with him.
You have the brief or not?
Yes, sir. We have.
Very good. At best Tuesday, not 2 weeks. For some other reason, I can accommodate, but these are not reasons. Non-communication with clients of statutory appeals.
On 19th, Your Lordship.
19th.
On 18th.
This is item number?
4, Your Lordship. On 19th, Your Lordship.
MS?
S. Nazneen, Your Lordship.
MS S. Najni. You're Nazneen?
Yes, Your Lord.
MS N.
Nazneen.
Nazneen, learned counsel for the appellant. But your name's not on record. So you're making a mention for whom?
Jed Alam.
On behalf of Mr. Jed Alam, makes a request for posting this matter after 2 weeks, as the appellant, they are unable to be in touch with the appellant. Since the matter is a statutory criminal appeal, the brief is available with the learned counsels on record, lists this matter on such and such date for hearing. It is made clear that no further adjournment on this ground shall be entertained. Yes, date.
On 19th, Your Lord.
19th.
A pleasure.
Yes.
May it please, Your Lordship? Lordship, I beg to mention item number 13, Your Lordship.
13.
Yes, Your Lordship. Matter may be adjourned for the day due to some personal difficulty of my senior, Your Lordship.
For the day.
Matter may be fixed day after tomorrow, Your Lordship.
Okay. Thursday, it'll be difficult. Tuesday, Monday, next week or at date. MS?
A dash, Your Lordship. On
MS
behalf of
8.
PWD.
MS A Das, Learned Counsel, mentions on behalf of Mr. T. Deori, for posting the matter on any other date due to personal difficulty of the learned counsel for the petitioner. Prayer is allowed, relist on such and such date. Did you?
Lordship, I beg to mention item number 3. Senior counsel Z Kumar is in court number 1 in a debt reference matter.
Okay, when do you want it?
My lord, any day next week. 18th, preferably.
Your name?
My lord, P. Dev Chaudhary.
You are for the petitioner.
No, my lord, for opposite
Have
party.
you taken, you are for any objection?
No.
Your name?
P. Dev Chaudhary.
P. Dev Chaudhary.
On behalf of
Mr. P. Dev Chaudhary, Learned Counsel, mentions on behalf of Mr. Jed Kaman, Learned Senior Counsel, leading the brief on behalf of the respondent on the ground, which is not opposed by Mr.
P. Sharma.
P. Sharma, Learned Counsel appearing for the petitioner, relist on such and such date. Yes, give a date.
18th, my lord. Obliged.
May I please, Lordship, with the consent of the opposite counsel, I beg to mention item number 7. Due to some personal difficulties, my senior.
What will remain in my list now?
My senior.
And these are all matters. None of the respondent has given any advance intimation to neither to the court nor to the APPs. They must have been burning midnight oil. So many old matters. Huh? The matters cannot go on and being adjourned. If you have some difficulties, some endeavor has to be also be made from your side. We come prepared to court. When I say I mean also the APPs. They don't come, isn't it? And the difficulty then is that they may have prepared 4 matters. Those 4 may have gone. Now the other 3 or which will be called, they don't know. I understand. This is what it happens. Yesterday also I made it very clear. Notice. In this court and criminal appeals, I'm making it very clear. Henceforth, no adjournment unless and until advance circulation of advance slip of adjournment is circulated. That is also subject to what court feels. It doesn't mean you give an adjournment slip, casually the matter will get adjourned. These are all matters. You must show some seriousness also. Yes, what do you want, ma'am? Which matter? Which matter? You are for the appellant.
Petitioner, I am for appearing on behalf of Mr. M. Hussain.
As prayed for by MS
E. Devi.
E. Devi, Learned Counsel, appearing on behalf of Mr. M. Hussain. Relist when?
Next week's any.
On next week or that date, on such and such date. Yes, next.
Next.
May I please, Lordship, I beg to mention item number 14, Lordship. Lordship, I have some instruction regarding Lordship amicable settlement, Lordship. Lordship, respondents are
What is the issue?
NIA.
Your name?
MM Zaman, Lordship. On
As
behalf of
Mr.
S.
M. Jaman, Learned Counsel, appearing on behalf of
Mr. S. Samarian.
S. Samaria, Learned Counsel, appearing for the petitioner, submits that there are out of court talks going on to settle the matter, which is not opposed by Mr. D.
We actually don't have the contact with the client.
But you're not objecting.
Not
isn't it?
objecting today, but
So I said only that.
there's no, we will take
the-
instructions.
Mr.
MSC.
MS Hussain, Learned Counsel for the respondent, relist. When do you want it?
Any day, Lordship, please.
After 1 week, did you? Rupak, date after a week. So and so. Yes.
On admission, item number 1.
Yes.
Two judgments, my lord, new judgments I would like to place.
Regarding that review of within period of 6 months.
Here admittedly, there was some 10 days delay, na?
My lord, there is delay
In the
Second
second
review.
review, not in the first.
So the suspension was on 28/6/24. So I can just
So
confirm the date,
28/6/24.
28/6/24.
My lord.
Now that 90 days period expires when?
My lord, as per my calculation, my lord, it expires on my lord, 27/12/24.
27,
As per my calculation,
90 days.
my lord.
27. Are you sure?
My lord, before that, the search memo was submitted, so that.
Mr. Gogoi, why always so much in defense? Why so much in defense? Is the court not entitled to understand the facts? How is the court going to author a judgment if the court doesn't even understand facts? Why do you all, I find you all become very anxious and cautious. Why? What is the
Sir,
requirement?
524.
You don't allow the court also to understand what the court wants to understand.
My lord, 1/5/24.
No, I just wanted first the dates.
28/6/24 is the
Twen-
suspension.
28/6/24 is suspension. Now, when does the 90 days expire?
My lord, 90 days expires on my lord 27/9/2024.
27,
9/24.
9/24. Now, within this period, first, I think charge was given on
18/7/24.
18/7.
7/24
So that was within
within.
7/24 charges. Then after expiry, there was no extension or there was an extension.
7/1/25.
7/1. Now, when does the 6 months expire?
My lord, if it is calculated from the date of suspension. it
No,
will-
not from
the
date of
amount
suspension.
Charge, my lord, on 17/1/25.
So this is also within
My lord,
17/1/25.
my lord.
Then after then again 6 months from 17/1/20 from
Yes, my lord.
huh?
Yes, my lord.
Next 6 months, but then that is not there. Now subsequently what will happen?
Yes.
That part is not there.
Now, my lord, during the pendency, the second review has been conducted.
That is after how many months?
My lord, on 26/9/25.
After 9 months from first review.
26/9/25.
So now this is the issue, right?
My lord, here one more, my lord, fact is this, my lord, the additional charge sheet was again submitted on 23/8/24.
Correct.
Additional charge sheet.
That is no bearing from the.
No,
first
but
review.
this first review is on 7/1/25.
Yes, my lord.
And since then, after about 9 months, you did a second
On 7/1.
review.
My lord, as per the office memorandum, the last paragraph, if we read the last paragraph, my lord, of the office memorandum,
Yes?
all the departments shall submit quarterly return of the personnel to the personnel B department with details about suspension order issued, memorandum of charges, charge sheet served upon the delinquent officer, employee, and if any extension of suspension period is given, etc. The personnel department will compile the reports received from the departments and place before the undersigned for a periodical review every 3 months. Every 3 months of the last 3 months suspension order for further necessary action. So, my lord, review is to be made periodically every 3 months. As per this office memorandum itself. And my lord, in the state rule, my lord, I did not find anything. But in the CCS rule, my lord, it is stated under rule 10(7)
That is not applicable.
that, my lord,
Deepak Mali's case.
my lord, beyond 180 days, suspension cannot be extended beyond 180 days. That is 6 months.
Anything else?
But this is the case, my lord, my second review has not been made within the time. So, my lord, this suspension order.
According to you, that time is
My lord, at best, it is 6 months,
not
Not
beyond
beyond
that.
not beyond that.
Okay. Yes?
My lord, so far as my lord, the last paragraph that my learned friend has just read out. This is regarding, my lord, supervising the, my lord, various suspension under the state government, my lord. It's not that, my lord, 3 months is the.
No, but Mr. Gogoi, after
Whether
the
it
first review,
My lord,
that is, as because your OM says that after issuance of memorandum of charge sheet,
my lord.
shall undertake a review within 6 months
Yes.
as regards the desirability to further continue with the suspension order. Now, suppose this is done, but within that extended 6 months period, also you cannot complete. Then what happens?
That-
Then what happens?
Here is a case, my lord.
So
that
now you see the OM is silent.
OM is silent.
Now, but the law has been laid down in
Yes.
Ajay Chaudhary.
Ajay Chaudhary has
So
been
what
laid
is
down.
that law?
Yes.
What is that?
Now, my lord, regarding, my lord,
Listen,
My lord.
what is that law?
No, he says, my lord, that Ajay Chaudhary is, my lord, regarding, my lord, a case where, my lord, there was a continuous
No,
suspension.
I'm not on that. But the main ratio there is not to unnecessary.
prolonged
Correct.
suspension.
So the basically it is prolonged suspension.
Article 21 will.
Correct. So now here,
Right.
if you don't have a fix further something and you do it at your own wish, then it defeats the everything.
Not
However, in your case, it is noticed that you have done it.
done it.
And it is done it after 9 months. Now that whether by the last paragraph of Ajay Chaudhary, maybe in this case that
Yes.
will not come in. I have to see it. But then at the same time, you see,
Yes, this-
if you don't clarify this, then there will be a series of such cases coming before this court,
Oh, yes.
and it will also give an handle to your government officials to first do it within the 3 months,
Yes.
then
Yeah.
extension and do it within 6 months, and then they will not do anything for years. How can that be? That will defeat the entire ratio of Ajay Chaudhary. That can't be. That is going to be in sure violation of Article 21 also,
My-
right? So that cannot be.
Yes.
In this case, however, considering that after 9 months this is done,
That
whether
means-
what I ultimately do, that is different.
In future, my-
But
Yes, it will be within, my lord, that I assure it will be within 6 months, my lord. If
no,
at all
it
we
has to be
propose-
clarified subsequently.
Yes, yes,
This notification doesn't take care of that situation.
I will convey, my lord.
It doesn't,
That is
and
gray area.
it will be difficult for this court to accept the contention of Mr. Saikia that after 6 months, now you do it within 3 months.
No,
That
that's
also
why,
will.
that's only a review of the.
Correct. So this court is mindful of that, because until and unless this OM is challenged and this is taken away and it is brought back to 3 months, that's a different thing. But this OM has already been looked by a lot of coordinate
yes.
benches and have not really said anything against it.
Lord.
It seems it is holding the field right now. Correct. So unless that situation come,
Lord.
till then this is how it is.
Fine.
But the fact remains, after 6 months, there is no clarification. But that has to be in terms of Ajay Chaudhary. It cannot be 1 year, 2 years, 3 years,
It will be 6 months again, my lord. Probably.
whatever.
That will.
I am not going to say that. I shall not go. Why should I say that?
Perhaps, my lord, lordship may,
CCS rules.
my lord, FR.
Huh?
FR 53, my lord.
Jackson.
FR 53, my lord.
Yes.
Well, the proviso provided. Doesn't got it, my lord.
FR 50,
53, my lord.
53.
51.
Yes.
To provide the manner, provided that where the period of suspension exceeds 3 months, the authority which made or is deemed to have made the order of suspension shall be competent to vary the amount of substances allowance for any period subsequent to the period of the first 3 months as follows. The amount of subsistence allowance may be increased by a suitable amount not exceeding 50%.
This is in relation to subsistence
Yes, yes.
allowance.
But Still, madam, it's
3 months.
there should be a review of this.
See, I am with you on this. I am not saying that after 6 months they can just do it at their own whims and caprice. I don't say that. But nonetheless, something right now it doesn't say it has to be done again after 6 months. It's silent, which this court is not approving. But nonetheless, in the facts of your case, it has been now done after 9 months. So because it has been done, I am finding it difficult to automatically say that it has gone, the suspension. Because that is in tune with paragraph 22, Ajay Chaudhary, the
Yeah,
conclusion 22, wherein Ajay Chaudhary also, after laying out everything, noticing that ultimately the charges that has been done, you see. So here also charges done, extension is recent. You are not saying, you're not on that.
I have not been paid any subsistence allowance.
So for that you have, that they will do in accordance
Yes,
with
but
law.
That's one aspect. And
That I can clarify.
I have been debarred from practicing anyway.
Huh?
I have been debarred from practicing.
Of course, the person under suspension who is getting the.
I am not getting,
Definitely.
one second, Mr. Saikia, if you,
Clarify
Mr. Saikia, if you are having something about the subsistence allowance, I will say, however, the subsistence allowance shall be dealt in accordance with law.
From next
May-
month
may I
itself,
make
madam,
it
it should be
happen?
paid.
May I make it
I can then record his submission. He says next month it will be paid.
If, as they are not paying the subsistence allowance, my lord, I may be permitted to make my practice, do my practice. I am a doctor.
That I
I'm a
shall
doctor.
not. I cannot do that, Mr. Saikia, please. That is not
On-
too
on
much.
top of that-
Anyway,
Madam, top
I have
of that,
heard you. Yes, you wanted to give something, give.
madam, this is a special case number 42 of 2025 against this petitioner.
Huh?
And against the petitioner by the CM Vigilance Cell, and he was behind the bars from.
Anyway, I'm not into all this. Why should I get into all this merits?
Madam, that judgment, madam, Ramanath Burman, I have just now given.
Ki judgment is sir?
Do you know that? Ramanath Burman.
No, this is only the,
Very beginning, I heard about.
hmm? Oh, yes. Yes. What do you want to rely from here?
The petitioner was suspended sometimes in 21/9/2021. And there was no review.
There was no review.
Oh, yeah. Now, finally, the Honorable Court, after discussing Ajay Chaudhary and various other judgments, allowed the authorities to go for review in 2025, madam. Say that you go for review now, and you follow the law laid down in Ajay Chaudhary. But you may kindly have a look at that while passing the order.
Are you still, after hearing so much, you are thinking I'm now going to automatically say this has gone? I have indicated the mind. Why? What is the use of giving me this Ramanath Burman? The problem is the court wants to dictate the bar makes it difficult by burdening us with
No,
judgments
then-
after judgments.
Then I'm not
Huh? You cite judgments when you think it is required. When the court is with you, why unnecessarily burden us with the judgment?
Then I'm-
It only delays the whole thing.
No, I will not.
There are so many criminal appeals lawyers I can see tiredly looking in before the court. When these matters gets over and those old criminal matters are going to be taken up.
The last
Huh?
time I'm not relying.
Yeah. Yes.
Offline.
Heard Mr. I.S. Chekia, learned counsel appearing for the petitioner. Also heard Mr. B. Gogoi, learned counsel appearing, you are appearing as the additional advocate general?
Yes.
Learned additional advocate general for the state. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking setting aside and quashing of the impugned notification whereby the petitioner on 28/6/2024 was placed under suspension by the Commissioner and Secretary to the Government of Assam Medical Education and Research Department. So, the brief facts of the case is that the petitioner, where do I get the relevant dates in your petition? Is there a list of dates here?
Yes.
Where do I get it?
While one matter is going on in court.
Yes, yes, that's all right, Mr. Gogoi.
Well, paragraph 3, what will find?
Starts from 3.
Paragraph 3, madam.
কি লিখিলা প্রণব? Was placed under suspension by order dated 28/6/2024. For the alleged ground of unauthorized absence from duties since 1/5/2024, with a further allegation of joining Hayat Super Specialty Hospital as CEO. Thereafter, the petitioner was charged sheet on thereafter a charges were served upon the petitioner on 18/7/2024 along with the statement of allegations. Accordingly, the petitioner replied to the same. On 23/8/2024, the petitioner was further served with additional charge sheet. Thereafter, the suspension of the petitioner was reviewed on 7/1/2025. However, the same is still continuing till date. It is the specific case of the writ petitioner that after the first review of the suspension and the extension thereof on 7/1/2025, which is within the 6 months period from the date of issuance of the first memorandum of charges. However, the suspension was not reviewed or extended. Thereafter, within the 3 months stipulated period, and instead the suspension was reviewed ultimately after almost 9 months from the date of the first review of the suspension, i.e. on 26/9/2025. Situated thus, the present writ petition has been filed. Mr. Saikya so-and-so, learned counsel for the petitioner, submits that admittedly the submits, admittedly no comma, submits that though the charges were furnished to the petitioner within the currency of the stipulated suspension period of 90 days, comma, and the review of the suspension and extension thereof was also done within 6 months from the date of the issuance of the first charge sheet. However, the second extension, second review stroke extension was not done for almost 9 months from the first review, and hence the ratio laid down in Ajay Chaudhary so and so reported in so and so is totally being violated. He further submits that the office memorandum dated 4/2/2020 clearly prescribes that all the departments shall submit quarterly return to the Personnel B department with details about the suspension order issued, memorandum of charges, charge sheet served upon the delinquent officer, employee, and if any extension of suspension period is given. And such details will be compiled and the reports and such details shall be submitted by way after compiling the same before the Chief Secretary to the Government of Assam for a periodical review every 3 months of the last 3 months suspension orders for further necessary action. He accordingly emphasized that it was imperative for the respondent to review the suspension of the petitioner every 3 months since the issuance of the memorandum of charges. Correct?
First review.
Since the first review. Since the first review, i.e., within 6 months from the date of issuance of memorandum of charges stroke charge sheet. Per contra, Mr. B. Gogoi and so and so submits that the office memorandum dated 4/2/2020 is silent as regard of any subsequent reviews to be undertaken after issuing the after holding the first review within 6 months from the date of issuance of the memorandum of charges stroke charge sheet. He further submits that in the instant case, since the second review has already been done on 26/9/2025, the relief sought in the instant writ petition warrants no entertainment from this court. Stop. I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the parties, for the contending parties, and have perused the material available on record. I have also duly considered the case law cited at the bar. The admitted facts are that the writ petitioner was placed under suspension by order dated 28/6/2024, issued by so and so, for his alleged unauthorized absence from work. Thereafter, on 18/7/2024, the respondent number, which is the respondent? The respondent number so and so issued charge sheet. And this was under Rule 9 of Assam Service Disciplinary Rules. Under Rule 9 of Assam Services, within bracket Discipline and Appeal Rules 1964, read with Article 311 of the Constitution of India to the writ petitioner.
Respondent number 2, madam.
R2, huh? It further appears that the 90-day time period as laid down by the apex court in the case of Ajay Kumar Chaudhary Supra, as well as the office memorandum dated 4/2/2020, issued by the Chief Secretary to the Government of Assam pursuant to the directions laid down in Ajay Kumar Chaudhary Supra, expired on 27/9/24. It further appears that it is undisputed that the charge sheet stroke charges were served upon the writ petitioner within the currency of the stipulated 90 days stroke 3 months from the date of issuance of the suspension order. It further appears that on 18/1/2025, an additional charge sheet was also furnished to the writ petitioner by additional charge sheet was by the respondent number 2. It further appears that on 7/1/2025, where do I get this? The first extension
In
review,
the affidavit filed by the respondent.
page number, please. 80.
89 of our additional affidavit. First review,
Yes.
7/1/2005.
88, I think, no?
It starts from 88, madam.
Yes. কি বলে লিখিলা? This is Commissioner Secretary R2.
Yes.
The respondent number 2, after reviewing the matter of suspension, it appears that it further appears that on 30/11/2024, the matter for reviewing the case of the petitioner for reviewing his suspension was placed before the review committee on 30/11/2024. And after careful and due consideration, it was decided to continue the suspension of the petitioner. Stop. Thereafter, on 7/1/2025, the respondent number 2 extended the suspension. Correct? This is the fact.
Yes.
It is thus evident that the review was also done within the 6 months period under the office memorandum dated so and so from the date of issuance of the first of the charge sheet. Before that 6 months expires when you said 17/1, na? 17/1, na? 6 months?
17-1.
That is 17/1/2025. Before the expiry, je koisla, 17/1/2025. However, thereafter, where is the second one? Where do I get that?
86.
9/2025.
Page 86.
Yes.
Page 86.
Yes. Thereafter, the case of the petitioner for review case of the petitioner, the case thereafter he agor nishtake likhiba case of the thereafter the case of the petitioner in the matter of his suspension was placed before the review committee in its meeting held on
Well, this was not placed before the review committee. The second review, my lord, was not
Second
placed.
review matter
First
suspended,
review was placed.
Acha, sorry,
but it was done by review committee.
on 25/9/25
Yes,
it is done.
yes.
On 25/9/2025 and accordingly the committee was of the after careful and due consideration of the facts and circumstances recommended further continuation of the suspension of the petitioner. Thereafter, the respondent number 2, wide order dated 26/9/2025, extended the suspension of the petitioner until further orders. It appears that the aforesaid review / extension was done after 9 months from the date of first review of the suspension.
19 days. 9 months and 19 days.
9 months and
19 days.
9 months and
19 days.
19.
19.
19. Okay. Approximately 9 months, 19 days. The short question is thus whether for not extending the suspension of the petitioner within no, don't say within. The short question is whether the continuation of the suspension of the petitioner is vitiated for not extending the same prior to 9 months
19 days.
19 days period. That is the issue.
Yeah, that is.
In this regard, well, I'll refer to 10-7.
Apt at this juncture to refer to the office memorandum dated 4/2/2020, which reads as under. Para 13 or 14, a judgment some sort of. মই ইয়াতে এটা ই লগাইছো তাত এইটো লিখিবা it further appears that all the departments were directed to submit quarterly return to the Personnel B department with details about the suspension order issued, memorandum of charges, charge sheet served upon the delinquent officer, employee, and if any extension of suspension period is given, etc. The Personnel Department will compile the reports received from all the departments and place before the undersigned for a periodical review every 3 months of the last 3 months suspension orders for further necessary action. Apt at this juncture to refer to the decision of the Apex Court in the case of so-and-so Ajay Chaudhary, wherein the Apex Court has held as under quote unquote para 21 and 22. Para 15 to as it is lower. Matter E loga so. It further appears that the state respondents have provided in the said office memorandum that even after the review, even after submission of the charge sheet within the 3 months stipulated period and reviewing extension, if any, within the 6 months period from the date of issuance of such memorandum of charges charge sheet, the matter of suspension shall be placed before the Chief Secretary to the Government of Assam for a periodical review every 3 months of the last 3 months suspension orders for necessary action. Hence, the said office memorandum appears to be in conformity with the ratio laid down by the Apex Court in the case of so-and-so. In the case in hand, though the respondent authorities have followed the first 2 timeline, i.e. issuing the charge sheet within the 90 days stipulated period of suspension and further reviewing an extension thereof within 6 months from the date of issuance of the said first charge sheet. However, the second review and extension thereof was carried out after almost 9 months, 10 days, 19 days. Mr. Saikya is correct in his submission that after reviewing the suspension within 6 months from the date of issuance of the first charge sheet and extension thereof, the respondent authorities cannot be sitting over such extension for an indefinite period of time, as the same shall defeat the defeat the ratio laid down by the apex court in Ajay Chaudhary Supra. Stop. I am in agreement with Mr. Saikya, learned so and so, to that effect. And in fact, upon careful perusal of the office memorandum dated 4/2/2020, it appears that though it is not mentioned in so many words, that subsequent review after the first review has to be done within a specific period of time. But applying the ratio, however, by applying the ratio of the apex court in so and so vis-a-vis the last paragraph of the office memorandum, it indicates that it indicates that the same should be done within 3 months thereof from the date of first review. It appears that the office memorandum so and so has it appears, however, it is Mr. Gogoi is correct also that it does not clearly spell out the set time frame. However, this court so far as the facts of the present case is concerned, the appellant has now been served. The suspension of the writ petitioner has now been reviewed. Has been reviewed prior to the filing of the case.
No.
Has
After filing.
has been reviewed, and extended thereof by a reasoned order. That being so, no interference as far as the present case is concerned is required. However, it is made clear that the writ petitioner shall not be deprived of his subsistence allowance, and the same shall be paid in accordance with law during the period of suspension. Correct? That is what you said. I'll edit the last part a little, huh? And maybe I will add one more clarification that you must clarify this position, the subsequent, because it's not fair to say that because you see that last paragraph is very clear. It talks about all these eventualities. He's right, Mr. Saikya is very right. It says the suspension order issued, the memorandum of charge sheet, if any extension of the period is given, and every 3 months these are placed. So 3 months, 6 months, and then every 3 months. You keep extending if you are not extending. So it seems that there is a gap, but that we can always clarify it. So a little more clarification will go. You may not get this order today, huh, Mr. Saikia? Yes.
For hearing. Supplementary date, item number 16.
Hey, Geeta. Yeah, to speak with yourself. I will judgment Monday. Yes, you have. If you need, yeah, I like it. Huh? Certainty position. Way to side the Yes. Anything?
Yes, my lord. What has happened here, my lord, there was an amendment in 2013. Before 2013, because our occurrence is both in 2019. The sentence was, my lord, it was, may extend to 2 years or with fine.
So maximum was 2 years.
Yes, or with fine. And that has been amended in 2013, after Nibaya,
You come under the old.
old. The fine provision is also there. And I have seen the court matter. I was doing course of investigation also. I was arrested, madam. I was in prison for more than 161 days, more than 4 months.
For how many days?
161 days. I was arrested on 17/3/2010, madam.
The date of occurrence is when?
Date of occurrence is of 2009, madam.
2000,
I was law later, madam.
2009. And FIR?
I'm coming to it.
31/10/2009.
31,
31/10.
2009. Now,
On 2/11/2009.
that's all right. And now you tell me, you were in custody when?
From 2/11/2009,
2/11,
2009,
2009,
and I was released on 12/4/2010, madam.
12/4/10
2010. Around 161 days.
custody. Around
161 days.
61 days. Okay. Rupak, trial court or records to Bhairav Jackson.
And there I have seen also, before amendment, there are cases, my lord, where the Supreme Court, my lord, allow them to go
Give,
for this compound. There are cases, my lord, I think.
can you find out in the FIR if a date, if the year is mentioned, age is mentioned? And if on the body of the FIR also anywhere the age is mentioned and say
Age of the accused.
a victim, age of the victim and the informant. Just read once the informant, because in the in the trial court judgment, it says that the informant have said she's 15 years. So where did they get that? Just verify that one. Yes.
These are cases where the conviction was of 354, my lord.
Compounded.
Compounded, but
For why compounded?
because the other party, my lord, agreed, my lord.
But your other party is missing today.
I don't know.
Yesterday he was there. Today he is missing. Huh? Today is the main day.
Morning, I feel in, my lord.
In the FIR lordship, our age is victim age is 15 years.
It is shown in the FIR body.
Yes.
And what about in the contents?
Contents of the FIR, it shows 15 years.
In the contents also?
Yes,
Okay. And what about his evidence now? Just verify that.
the informant's evidence of.
Informant's evidence. Mr. Kotoki, which paragraph of this?
Regarding quantum part, I'm coming to your lordship, page 6, my lord.
Page 6. Mr. Kotoki, one more decision in case you have it. Otherwise, I'm sure you will be having those diaries where it will be written. No. On force. The ingredients of 354. Because I kept thinking how force will come.
Force will come because it is a sexual assault, my lord. When the assault, as a result of assault, I'm outplacing her modesty, my lord.
No, but then
That-
her consent, because if the courts takes her to be a minor, then consent become immaterial. That's how.
That's how. Otherwise, my
Nayak requested posting the matter next week. Prayer is not opposed. Relist on such and such date for further hearing. And the date detail.
oblige.
Number 2.
May I please, lordship?
Hey,
Is it,
you come here. One second.
lordship?
A criminal offence Dixon. Otherwise, I'll forget.
Lordship. This conviction. Under
Yes.
section 325 for 6 months,
325.
5. IPC for 3 months, 6 months, and a fine of 5,000 in default 2 months. So in
325, no? This is the
325.
offensive.
offense.
325
IPC.
is basic, that's so.
From the doctor, it is
Just
blunt
one
weapon,
second.
but allegation is of sharp weapon. So some inconsistency is there.
No, I just wanted to have a
Good.
quick glance of
Lots.
325 before we start. Oh, they can't. Unlike you both, I don't have these by heart.
Nowadays, we are also in BNSS, we are also.
It's very difficult.
Very
It's like
difficult.
learning a real, going back to the school, huh?
Lots, again,
Voluntary causing grievous hurt.
give us that.
And here you've been sentenced for
6 months
6 months.
and fine of 5,000 in
So
default.
maximum is 7 years, right?
Maximum is 7 years
6 months,
and fine of 5,000
5,000 fine.
in default 2 months.
And
The occurrence is of 21/4 2008, lordship.
2008.
21/4. And it took place in a Namghar where meeting was taken place, lordship.
But this is revision.
This is reviewed, right?
So limited
So,
jurisdiction.
concurrent finding. that is there,
Concurrent finding.
Because trial court has convicted.
So
an
what
appellate
is
court.
the
Means lordship will kindly see the PW1 who is the injured witness.
no, but can
He-
this court now appreciate or
That part,
reappreciate the
lordship,
facts?
That part lordship, because again he has
You have to
stated
show
that he
what
was
is the
assaulted with-
patent manifest
Correct.
error.
correct. He has stated that he was assaulted with an axe, but the doctor has found blunt impact. If one is,
X.
they
And,
are also have an incised wound. Because
so the X was seized,
that was not also not seized.
not seized.
Not seized. Even
And,
his
and
garments were also not seized.
eyewitnesses.
Eyewitnesses, but they are saying that in court they have deposed that they have heard from the injured witness, though they were present there.
But the conviction based on those witnesses,
Along with the
treating
injured.
them as eyewitnesses,
Along with the.
treating them as eyewitnesses.
They have taken the injured to hospital.
But they have not seen.
And what does the injured say?
Lordship.
And what does the injured
Injured
depose?
stated that while the meeting was going on from the backside, the accused person assaulted him with the axe
So
on his left
are
hand.
you saying he didn't see?
No, not he. The others, they were also present, but nobody has supported him.
Oh,
There
acha.
were many people.
Many
almost
people, about 18 to 19.
three were the witnesses. And they have a enmity between the accused.
That
and
has
the-
also come.
That is also there.
Along with his father, there was some enmity.
So are you both agreeing that the evidence are slightly insufficient?
Little discrepancy is
That
there.
part.
But Lordship, he was injured. The
That's
fact
all
is
right.
injured.
Just because he's injured, one cannot be convicted unless and until the evidence are there.
moreover,
Sufficient
doctor
evidence
says
has
that
to
it
be
was
there. If
planned-
there is a doubt, then
Lordship.
that benefit will go to the accused.
Definitely, definitely.
He is there, but Lordship.
So
the
you are agreeing it is there, you said?
Lordship,
Did
the
I hear you
victim-
correctly, Ms.
It is
Begum?
correct. Lordship, let me, Lordship, he is the informant. The injured is the informant.
Hey, interview guy.
He is the injured informant and Lordship, he was immediately taken to hospital. And there was two reports from the medical officer. One that he was simple injured. But
He was simple injury.
Simple, a lacerative injury is there.
Lesser.
The injury was simple. Then he told that. you need-
Lacerated is that
That.
the- but
thorny qua.
he had told that you'll have to go through an X-ray. Then on that suggestion, he did an X-ray. After going to the X-ray report, he came to know that there is a previous injury. As there
But
is a
that
fracture.
lacerated cannot be from an X.
From an X. That's what I'm submitting.
Two sides, the definition is that there are two sides of an X.
The blunt side of the X.
But
It is from the
he has
back.
not stated from the blunt side he was
He didn't see
at-
that.
assaulted.
From
No,
the
that is-
I have seen it.
backside.
No, that is presumption. Whether it is from the
Anyway,
back
Mr.
side.
Talakdar, it looks like I'll have to
Lord.
see everything. So you want to start from, take me through the judgment?
Not the judgment, PW1 from the.
It's
petition-
annexed here.
Not annexed. In my petition, I have stated, recorded the evidence of the witnesses.
So let's see the judgment.
Just
Where is the trial court
trial
judgment?
court is lordship. It starts from page 13.
I'm sure everything is stated there.
It is stated here. But evidence directly that has not been quoted.
No, if anything specific you want to show, then maybe you may read it from the
Not-
trial court
not-
records
Lordship, lordship.
where you have extracted them in your petition.
Lordship.
Where?
On page number 4 onwards. I think.
Ms. Begum, can you kindly
It is
a
verified.
trial
She
court
can
should
verify.
video.
Lordship.
While he's reading, you can see whether it is, you have.
Trial court is here. Para 4, your lordship will kindly see the evidence of Laban Das. He is the informant as well as the victim.
Stated one, I'll have the assamese. version.
No, but
That part is tested. She can verify it.
while Mr. Talukdar is reading, you keep going through.
Yeah.
Particular one.
If there is anything not there, you point out,
Lordship.
Lordship.
isn't it? It'll be easier then.
Easy.
Because sometimes some vernacular words I may not understand properly.
Lordship.
Lordship.
And the handwriting is also a bit.
Yes,
difficult.
yes. Yes, Mr. Talukdar.
Lordship. No, she has not found it.
CGM को person ही listen क्या बोले?
CGM हो.
Palan? I think not so bad, I can go. with that.
Not so bad.
Not so bad handwriting. I can-
So, page 4, your lordship, you'll find para 4. PW1 Sri Laban Das.
One sec. Hey, at a pencil, did you take it? If there is something you want to read later, just underline and read it out later after Mr.
Lord.
Talukdar finishes, huh?
Lordship.
Yes.
PW1 Sri Laban Das, the informant come victim of the instant case, deposed that a meeting was held at the premises of the Namghar, and Kartik Das is the accused petitioner, was sitting behind his back, and he was sitting there with an axe in hand. When he moved back, Kartik gave a blow on the left hand and then he fell down. Thereafter, he rushed to Kamala Kalita's house. The accused also asked the people present in the meeting not to move. People present in the meeting saw the occurrence. Thereafter, he was taken to hospital for treatment. On the way, he met police. On the next day, police asked him to lodge the Azahar. Exhibit 1 is the Azahar. 1 by 1 is his signature. In Frost, PW1 deposed that meeting took place in a courtyard of the Namghar, and about 19-20% attended the meeting. And before assaulting him, the accused told everybody not to move from their place.
Who's
and
Kartik Das, accused?
Accused. He is the
You are the.
I am Kartik Das.
So, Ms. Begum, it is clearly mentioned there, now when he moved back, Kartik Das gave a blow.
Lordship, why to Laban Das or point name?
PW1. Laban.
What do you want to point?
Eh?
Yeah, but
Mr. Hajorika?
it will PW2 different. Ah, yes.
No, yeah, episode.
Oh, yeah, you need to take it.
এইটো হৈছে back side of our part. So you can read it, the vernacular one.
I can.
এইখিনি part, মাৰ part.
পঢ়ি দিয়ক।
নামঘৰ meeting of.
Meeting of.
And the premises of the Namghar and Kartik Das. What does
No,
it
it is
say?
in a
That a meeting
courtyard.
was held at the premises of the Namghar.
It is
And
a-
Kartik Das was sitting behind his back.
back.
And he was sitting there with an axe in hand. When he moved back,
He assaulted.
Kartik Das gave a blow on the left hand and then he fell down. So hand is left,
Hand is
hand, not in the vital part.
not a vital part.
Thereafter, he rushed to Kamala Kolita's house.
Only one single injury
In the hand.
in the hand.
How can that be grievous?
That's that too by blunt force impact.
He had a fracture.
No, that is not stated by a doctor regarding fracture.
All right, but
Go on.
apni
Then you
kind
will
of-
also find PW2.
yes,
One of the person who was there, Ratneshwar Das. He was present there in the meeting.
neighbor.
No, no neighbor, all our neighbors, because then he was present in the meeting.
Yes.
A meeting on the day of occurrence, but he does not remember the date of occurrence. And while the meeting was going on, somebody told him not to move. Somebody has not identified the accused. And thereafter heard the sound of PW1 shouting that he was assaulted. And thereafter he was taken to Mirza Hospital for treatment, but PW2 has clearly stated that he had not seen the occurrence himself with his eyes, but later on heard about the incident from Labondas. So again, he has evidence. Though he was present there, he has not seen the occurrence. Only he heard the shout of Labondas. Thereafter, he was taken to hospital, and he heard the incident from the injured. In cross PW reports, the meeting was held in the light of lamp. Even light was there. Laban shouted that he was assaulted and he fell down. But they could not identify the accused who was assaulted. Then again, PW3, same type of evidence. Reports that he was also present in a meeting on the date of occurrence, but he does not remember the date of occurrence. And while the meeting was going on, PW1 shouting that he was assaulted, and thereafter he was taken to Mirza Hospital for treatment. But PW3 has clearly said he has not seen the occurrence himself with his eyes. And again, he has heard it from Labondas. Then PW4 is also same. Then you'll also find PW5, the doctor. Dr. K. Sharma reports that he examined the victim on 21/4/2008 at 11:45 p.m. at Mirza and found one lacerated wound on dorsal aspect of the left upper arm.
What?
One lacerated wound on the dorsal
Doctor is
aspect.
4, na?
Lordship.
4, right? PW4 is a doctor.
Five.
5.
Page 6. Dr. K. Sharma found one lacerated wound on the dorsal aspect of the left upper arm. So how it can be a grievous one? He found the injury was fresh and was bleeding. Advised X-ray on the left arm. Exhibit 3 is the injury report.
But here, his opinion here, how is it grievous?
How is it grievous? Then in the opinion, he says that injury was grievous caused by blunt object. How X can be a blunt object? That part is also there.
That could be the
But he has not
backside.
stated from the other
No,
side.
we don't know. So it could be from the backside
But
going back.
what about the
But the only
lacerated-
thing is that
lacerated wound?
how is it?
How is
And-
lacerated?
And nobody has seized the X,
X,
no?
that is also not there. Neither the
All the
conveyance
other
was-
witnesses have said X.
No,
Huh? Only PW1 have said X.
only PW1 has stated.
Now 2 doesn't say anything. Assaulted. 3.
Because other
three
witnesses, they have not seen the X
assaulted.
as well as the person.
Correct. That's what I'm trying to find out.
Not
So maybe then the X was not there.
Not there.
3 doesn't say.
It doesn't say. 4 also doesn't say.
Shouting that he was assaulted and thereafter he was taken.
The 4 also doesn't say.
Or deposed when so at the meeting. He was only present in the meeting.
Meeting. And heard the sound of PW1 shouting that he was assaulted. With what he was assaulted?
In fact, he clearly said that he had not seen the occurrence himself with his eyes.
Eyes. Only heard it from.
Four also shouted that he was assaulted.
Same.
And he fell down. But who had cut, he did not know and he did not name.
These
Five
three
is the
witnesses
doctor.
are
6 is the IO.
2, 3 and 4 same. Only 6
And
witnesses.
in 313, have you said, explained
313,
it?
I do not have the 313. I'll have to check this out.
Now, what did the trial court do? What was the findings of the trial?
Finding
court?
that I'm.
So looks like only the injured's testimony. No?
That two doctor, this ocular version and a doctor's that is not corroborating each other. Lacerated, then how come it
It
becomes
could be a simple hurt.
maybe 323 maybe
It can be converted
converted to 3.
because it appears there is nothing probably in cross to discredit the the injured. And why should the injured lie? He clearly said the name.
One thing is clear that he has received injuries.
That's right.
But
He
what
has
kind of
received
injury? That your
injuries.
lawsuit will kindly look into. Injury is
Because
there.
it's not that he's got his hand has been fractured or
Fractured and it will be- Fracture is not there, only lacerated. So for finding a lawsuit, page 16 onwards of the trial court.
and 326 is that dangerous weapon.
Danger.
So that means even this is not clearly proved. X is a dangerous
Had it
weapon.
been axe, it would have been dangerous.
326.
Even his garments not seized, blood not.
So out after just another Ms. Begum, please verify apart from PW1, has anybody else seen the assault?
That is, I'm going through.
Big, I want to just see if anybody who says you have seen and has mentioned the X or not. I have seen in the in the court's
Judgment.
pleadings, nothing is mentioned.
That one I'm going through, Lordship, that PW2 Lordship, in the cross part, whether he have mentioned about the X or not.
Not cross, chief part.
Chief to science, chief my poana,
Chief it is not there. The court is asking about the chief.
But he have said that Lavon Dahe, the accused have
Lavandas is injured.
victim kole je accused have assaulted him and he immediately
No, but he doesn't say assaulted
Assaulted with
me
what?
with the X.
That is not there.
treatment
And he has not seen.
treatment
You see, he has also not seen.
he have not seen, but he was in the meeting. But
Oh,
he-
whatever. You see, now,
when
see,
he
there
had the
are
halla.
two things.
Two-
Right
yes,
now,
Lordship.
let's assume for a minute that
Lordship.
yes, he has been injured because that is obviously he's injured. And the nature of the injury is that in the hand, right? In the hand. Now the question is what and how.
Lordship, he have-
If you bring X,
he told one thing. Lordship.
it changes a little bit of.
PW2 told one thing, that after the incident, Lordship, he told everybody to keep still and he moved the X and he fled.
Where?
Access.
X, sir.
PW2.
Huh?
Like what?
Apre ase one.
Please see it properly. It is somebody's liberty that is we are
Sir, Lordship.
concerned.
Access or one.
If you want, I can give you time. I can have it tomorrow, but have a look at the evidence.
In the Lordship, in this part, my English to my marriage, Lordship, in PW1 also.
And
Lordship,
why don't
we
you
have
do one? Why don't you do one thing, Ms. Begum? Why don't you read all the evidence? They're just short evidence. Just read it once.
English.
No, that's the vernacular only. You can read the vernacular. So just read it loud for the benefit of everyone from PW1. Yes, Mr. Sharma, you want to assist? Just read it. Let us hear it together. One, start from one.
One victim of one.
Main are those 1, 2, 3, I think.
3 and 4.
One is the injured.
Yes,
One is the
read
injured.
Why, Assamik, Sini Pao,
louder, Mr. Sharma. Huh? Oh, sorry,
Is
Goswami.
Goswami.
I get very confused.
Yes. মই আছামিক চিনি পাওঁ, আমাৰ গাঁৱৰে হয়। ইমান তাৰিখে ৰাতি আমাৰ গাঁৱৰ নামঘৰত প্ৰাংগণত হৈছিল মিটিং। গৈছিলো, নামঘৰত ৰাজহুৱা মিটিং চলি আছিল। মিটিঙত মই আছিলো, বহি আছিলো। তাৰ পিছফালে কাৰ্তিক দাস ৰৈ আছিল। পিছফালে হাতত এখন কুঠাৰ লৈ আছিল। মই পিছফালে ঘূৰি চাওঁতে মোক কুঠাৰে ঘাপ মাৰি দিয়ে।
Muk kuthare?
ঘাপ মাৰি দিয়ে।
ঘাপ
ঘাপ মাৰিছে আৰু মোৰ হাতখন জখমী হয়, বাওঁ হাতখন জখমী হয়। মই তেতিয়া পৰি যাওঁ। তাৰ পিছত মই দৌৰি যাওঁ আৰু কমলা ঘৰত গৈ পৰি যাওঁ। সি এগেইন আছামীয়ে মিটিঙত থকা মানুহ লৰচৰ নকৰিবলৈ বাবে কয়। ঘটনাস্থলী কমলা কলিতাৰ ঘৰ 100 পৰা 400 মিটাৰ হয়। মিটিঙত মানুহ বহি মিটিঙত মানুহে ঘটনা দেখিছিল। আছামীয়ে লৰচৰ কৰিবলৈ মানা কৰি তেওঁক কুঠাৰখন ঘূৰাই পলাই যায়। That means he is revolt ex-man.
That was the victim.
কমলা কলিতা মানুহে চিঞৰি দিয়াত গাঁৱৰ মানুহ যায়, ঘৰৰ পৰা আহে। তাৰ পিছত গাড়ীত মোক ৰাইজৰ মানুহে PHC লৈ যায়। বাটতে পুলিচক লগ পাওঁ আৰু হস্পিটেলত মোক নিবৰ বাবে কয়। মোৰ হাতখন চিলাই দিয়ে আৰু এক্সৰে কৰিব দিয়ে। ৰাতি এক্সৰে কৰিব নোৱাৰিলো। পিছদিনা থানাত পুলিচে আজাহাৰ দিবলৈ কয় আৰু এক্সৰে কৰিবৰ বাবে কয়। পিছত আজাহাৰ দিয়া থানাত দিলো। মই লিখিব নোৱাৰাত
Exactly what you have translated,
Yes,
that same
মই
thing.
লিখিব নোৱাৰাত, that is নোৱাৰাত
Okay, I think the rest is not relevant.
Yes.
PW2,
It was the incident of night lordship.
that's
Night,
okay.
So lordship, they may not see exactly lordship, but immediately they were there. He fell
That's
down
all
and
right. Now let's go to them
PW2.
PWD.
and see what they said.
মই গোচৰীয়াক PW2 মই গোচৰীয়াক চিনি পাওঁ, আছামিক চিনি পাওঁ, একে গাঁৱৰে। ঘটনা আজিৰ পৰা এক বছৰ মান হৈছে। এদিন গৰম কালি 9 মান বজাত গাঁৱৰ ঘৰত প্ৰাংগণত মিটিং, নামঘৰৰ প্ৰাংগণ হৈছিল। উক্ত মিটিঙত উপস্থিত আছিলো। আছামী আৰু গোচৰীয়াও আছিল। মিটিং হ'ব নহ'ব কৰি থাকোতে চুপ বুলি কোনোবাই কোৱা শুনো।
Beating?
হ'ব
নহব হৈ থাকোতে চুপ বুলি কোৱা শুনিলো।
কোনোবাই কোৱা শুনিলো।
কোনোবাই
It's not
কোৱা
seen.
শুনিলে। তাৰ পিছত লবন দাসে মৰিলো বুলি চিঞৰে। তেতিয়া লবন দাসৰ বাওঁ হাতত কটা জখম দেখা পাওঁ আৰু
Kota.
কটা জখম দেখা পাওঁ আৰু মই তেওঁক ধৰো আৰু তেওঁক ধৰি মিৰ্জা হস্পিটেললৈ আনো।
Kamala, that part is not
Expert is
consistent.
not there.
No, he said he ran to somebody's house, no?
That he has not also been examined. Kamala Kulita.
But here, this guy doesn't say. He
That
says he took
doesn't-
him to Mirza.
Direct to
তাত
hospital.
ট্ৰিটমেণ্ট কৰাওঁ। পিছদিনা এক্সৰে কৰাওঁ। তাত হাড় ভগা বুলি জানিব পাৰো আৰু
And
বেণ্ডেজ
he
কৰি
is saying
দিয়ে।
Harbhanga.
Doctor doesn't say.
Doctor doesn't say.
Doctor said not.
Fracture.
Yes, sir. He has suggested to do the X-ray. Then in the second report there is X-ray fracture.
Anyway.
In the injury report probably. no?
বুলি জানিব আৰু বেণ্ডেজ মাৰি দিয়ে। 1 মাহৰ পিছত ঘটনালৈ যায়। মই নিজ চকুৰে দেখা নাই। পিছত লবণৰ জানিব পাৰো যে
Nisokore dekha nai.
দেখা নাই।
He
But
didn't see the assault.
Assault he has not seen.
He has not seen, but he is present in the meeting.
That's all right. You see, Mr. Goswami, right now I am not, I don't see any prima facie case of acquittal at all. As of now, I'm sure Mr. Talukdar has not finished, so I don't know what more he will argue. But whatever I have seen from there, it appears that maybe it has happened. But whether that is that X was involved or not, whether that grievous thing, because it's a lacerated wound in the left hand.
Left. But if fracture is there, that will be grievous.
So,
Grievous
so
in-
that is why now
Yes.
let's continue.
মই লাবণ বছৰ চিনি পাওঁ।
Who is that?
PW3.
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 Lordship, the thing is that the meeting was at 9:30 to 10 at night, Lordship. So, Lordship, about the light and all is also there.
In cross, they have said light was there, light in cross, he has admitted.
They're all nearby. They know
গাঁৱৰ
each other.
Know each other.
নিজৰ নামঘৰৰ অংগনত
হৈছিল।
হৈছিল মই নামঘৰৰ ওহোৱা
How
meeting-
many people were there total?
According to PW1 informant in cross, he has said 19 to 20%.
Why nobody have seen then?
Oh.
Meeting
PW1.
But there are less people.
Less
that is why
people.
meeting was not convened. That is.
How many people?
That is
That
exactly
Maybe
the
not.
figure is not. mentioned.
Anyway, let us stop these commentaries and finish the evidence first. Let us see on record what has come. It'll become easier then.
Lots.
Oh.
Yes, continue.
মই মিটিঙত সভাপতি আছিলো কিন্তু মানুহ কম উপস্থিত থকাৰ বাবে মিটিংখন নহল তেতিয়া তাত উপস্থিত থকা মানুহবোৰে এই বিষয়ে আলোচনা কৰে কিয় নাজানো that is not লবন দাসে মিটিঙত বুলি মৰিলো বুলি চিঞৰে মাৰিলে বুলি চিঞৰে তাৰ পিছত লবনৰ বাওঁ হাতত আমি কটা জখম দেখো বেলেগ মানুহ এঘৰত নি
Yes, supported
অলপ
that part.
পিছত মিৰ্জা মেডিকেললৈ নিওঁ তাত চিকিৎসা কৰা ঘৰত আনো পিছদিনা এক্সৰে কৰিবৰ বাবে আনে কাৰ্তিকে কৈছিল কাটিলে মই কিন্তু নিজে দেখা নাই লবন দাসে মানে
Understood. I am following.
he said to that Kartik
Following.
medical ভাল নোহোৱাত ভাল হয় that is
Medical কি?
medical
মেডিকেলত
ভাল নোহোৱা।
ভাল নোহোৱাত তেওঁ
যাৰ
Anyway, that may not be of much relevance.
not important.
Yes, next.
Oh.
PW4.
PW4 মই গুচৰীয়া আসামিক দুই পক্ষক চিনি পাওঁ ঘটনা আজিৰ পৰা 1 বছৰ 9 মান বজাত আমাৰ গাঁৱৰ নামঘৰ প্ৰাংগণত হৈছিল মিটিং আছিল নামঘৰত কিন্তু কোৰাম নোহোৱাৰ বাবে মিটিং নহল
Quorum.
তেতিয়া আমি বেলেগ বিষয়ে আলোচনা কৰি আছিলো মই মিটিঙত বহি
থাকোতে।
আছিলো বেগত বহি আছিলো আৰু এইটো কি হেৰি ন কাৰ্তিক দাসক ৰৈ দিয়াৰ পিছত ৰৈ যোৱা বস্তুবোৰ মোক দিবৰ বাবে কওঁ তেনেতে হাল্লা হয় আৰু তাত থকা
চাহ দিয়াৰ পিছত
তাত থকা লেম্পটো চিটিকি পৰে আৰু উমেশ দাস মোৰ ওপৰত বাগৰি পৰে এইটো ভিক্টিম লবন দাস মোৰ ওপৰত বাগৰি পৰে তাৰপিছত থিয় হৈ দেখো মানুহবোৰ দৌৰা-দৌৰি কৰিছে আৰু লবন দাসক মাৰিলে বুলি শুনা পালো লবন দাসক ওচৰৰ মানুহ এঘৰত লৈ যায় লবন দাসৰ হাতত বেণ্ডেজ আৰু
Okay, that is same. Next.
exactly the same my lord.
Next 5.
5 is the my doctor
Let's see the doctor.
Doctor says, my lord, lacerated wound is found in the present in the left arm, measuring
so and so
3 into bleeding present. X-ray
report
there is fracture on the
So that
Left
part comes.
humerus.
Just underline that part, please.
left humerus. That is
So that is exhibited by the doctor.
X-ray.
It has to come from the X-ray only. Okay.
Doctor will-
Now, after that is the IO.
and
Anyway, but Mr. Talukdar,
injuries-
see, it's the revision jurisdiction. What is the illegality committed by the trial court?
Finding that one, I'm like, Your Lordship.
What
Regarding one
illegality?
finding.
There can be two views,
Lordship,
but
can you see-
ultimately,
In the lower portion of page 17, Your Lordship, you can see the trial court judgment.
That finding, whether it is correct or not, that your
Yes,
lordship can
yes.
say. Regarding the injury part, lordship.
Yes,
In from the fifth line from the top, we have
yes.
considered the submission of the Learned Defense Counsel in light of the facts and circumstances on the record. We find no force in same. It is true that the medical officer has submitted 2 reports.
Where are you reading?
In
from?
page 17 of the.
I have page 17.
Lordship.
We have considered.
Internal is 5, lordship.
Huh?
Internal page, we have considered, right?
Okay.
From there.
Yes.
We have considered the submission of the Learned Defense Counsel in the light of the facts and circumstances on the record. We find no force same. It is true that medical officer has submitted 2 reports. Exhibit 3 and 2 by 2. Exhibit 3 is the first in point of time wherein he stated having examined the victim on 21/4/08 at about 11:55 p.m. and having found lacerated wound over the dorsal aspect and left forearm. He advised for X-ray until issuing Exhibit 3. X-ray report has not been produced before him. He explained the circumstances under which he has to issue Exhibit 3. An X-ray report so produced before him reveals that injured got fracture injury over the shaft of left humerus bone of the forearm. Therefore, he issued Exhibit 2 by 2. There is no
Find anything.
lower portion.
Sorry, I'm a little fast.
Although the victim stated that the injury got by him has been caused by sharp side of the axe, yet the medical evidence never supported the same. Considering the dimension of the injury, the impact of the force applied, I am inclined to hold that injury got by the victim is caused by blunt side of the axe. That is a presumption, lordship, by the childhood. That I am, because had it been axe, there ought to have been incised wound. How lacerated than fractured,
Because from backside. he
and
was
that
hit.
axe was not never seized by the police, and neither the other witnesses they have seen the axe, and they have not supported even.
Can't show
All right,
faculty prosecutor.
Miss Begum,
Lordship, can
he
you
has a
consider-
right to complete his argument. Let the petitioner complete. If both of you argue at the same time, how will this court
No.
appreciate? I'll only get further confused.
Yes, Lord.
My only submission, lordship, can you consider the sentence part? Considering the fact 2008 matter, that part also lordship can consider. Otherwise, injury is established, that I'll have to submit. Injury is established.
And fracture,
And
that 7th thing has come.
that has come in.
Till I didn't, I was thinking there was no report.
After X-ray, it has come.
It has come and the doctor have exhibited that X-ray report.
That is,
And it has, you see, obviously that when we go to the doctor, he on the first time, he may not be able to say, he will always say,
Then-
go and make an X-ray. So that
that
is
okay.
there.
But the fact remains that others they have not seen, even they were present.
How much? You've been given 6 months.
6 months.
What more?
Some
Huh?
relief your lordship.
What relief? Maximum is how much?
Maximum.
7 years. Lord.
7 years.
7 years.
I can make it 1 year after notice.
Sentence point your lordship.
And how many months did you
Most probably it was bailable offense he was not
from the
used
day
to.
one? Oh, this is a
It's a
bailable
bailable
offense.
offense.
Bailable offense. Sorry. No, it's non-bailable.
No.
325.
325.
325. Sorry. Bailable. Maximum
And-
7 years, you've got 6
And
months.
at that point of time, he was about 23 years of age at the
Not
time of
of-
incident. Only that sentence point your lordship. Otherwise, it is established.
Miss Begum, you want to say something? You can help me when I am dictating your submissions. Then you help.
It was during a night hours, Lord, and in village.
All right. You see, I am not sitting as an appellate court in this matter.
For that.
Had it been an appellate court, the decision may have been also different. We don't know. Because then I would have to be reappreciating and correct. And after doing that, if I hold something else, that was different. But right now, I have to only see if there is any illegality, manifest illegality committed by the trial court and the appellate court. Apparently, it's a concurrent finding. No, both courts have. Where is the appellate court's finding? Page?
Age. Page 31. Para 10 notes. No. Finding. Page 31. Para 10.
para 10, na? On
Lordship.
one of the grounds.
Lordship.
Rupak is flat. Kini শেষ হৈছে দেই। নোলাই এইখন। ভাৰ্গৱক এইফালে আহিব কোৱা। কোন আহিছে? হ'ব, ঠিক আছে।
Actually, from para 9 it starts. And
Okay.
he was absconding, so that also court has taken into account. As because he was absconding, that presumption was there. And he was known as the absconder in the search.
The only thing I don't know if I start, maybe it'll go towards the break. Mr. Chaudhary, I don't think before break, I'm going to just start. I've just completed the hearing, so I'll dictate it now, the judgment. So let's see how, when this gets over.
He was absconding. That control lines.
Judgment, huh? Criminal revision. Item number 2 koi diyo ko. Rupak. But Mr. D. No, something more is there. No, D. Only the Talukdar Learned Counsel appearing for the petitioner. Stop. Also heard MS A Begum, na? A Begum learned APP for the state respondent. Stop. By way of this petition under section 401, read with section 397 of the CRPC 1973, the petitioner is challenging the judgment and order dated 5/5/2010 passed by the learned Chief Judicial Magistrate Kamrup, Guwahati, whereby the accused petitioner was convicted under section 325 of the IPC and sentenced to undergo simple imprisonment for a period of 6 months and a fine of rupees 5,000 in default to suffer simple imprisonment for another 2 months in GR case number 31088, 2008. And the judgment and order dated 15/9/2012 passed by the learned additional session judge Kamrup, whereby the appeal filed by the petitioner was dismissed by upholding the aforesaid judgment and order of conviction of the trial court. In the brief facts of the case is that on 21/4/2008 at about 10 p.m. at night, the informant stroke PW1 was attending a meeting at the premises of Bar Pratima Makhuti Rajkhwa Namghar, wherein all of a sudden the accused stroke petitioner administered one blow with an axe over his left hand and caused serious injury. Accordingly, an FIR was registered and a case was registered under section 326/307 IPC. দি দিব পাৰে ভাইড Palasbari PS case number 79 of 2008, page 14 on judgment that পাই যাব. Accordingly, investigation was conducted and upon completion, charges was framed under section 326/307 IPC against the petitioner, and upon the
Charge was framed under section 325.
325.
Charge sheet was filed under.
No, no, I'm coming. কি বুলি লিখিলে? Charge sheet was submitted under so and so section, and thereafter, upon the same, upon the case being committed to the court of learned session judge Kamrup, comma, the offense being triable under section 307 IPC, the additional session judge Kamrup, having found not required.
Remanded back.
Correct. Not required. Ultimately, charge was framed under
Under
section 325 IPC by the trial court. During trial, the prosecution examined as many as 6 witnesses, including the medical officer and the investigating officer, and the defense did not examine any witness, and his case under section 313 CRPC is of total denial. Stop. Page 4 আছে, paragraph 4, 5, 6, 7, 8 দি দিব। খালি ইয়াত বেক্স টু ষ্টেট বুলি আছে তো আপুনি PW1 এতিয়া নিদিব, ৰ'ব এতিয়াই নিদিব, সেইখিনি নিদিব, ইয়াত আপুনি লেখক upon the trial being concluded, the trial court convicted the accused petitioner under section 325 of IPC, which upon being assailed before the appellate court, the same was upheld. The conviction was upheld. Situated thus, the present revision petition has been filed. Mr. Talukdar so-and-so submits that the evidence on record does not warrant conviction of the accused petitioner under section 325 IPC, and that he further submits that the alleged weapon has not been seized, and in any case, the lacerated injury as stated by the medical officer cannot have been inflicted by an X. He further submits that there is no cogent evidence to show that the accused petitioner assaulted PW1 with an X, as none of the witnesses who were present has seen the occurrence. Stop. He further submits that the ocular evidence of PW1 that he was assaulted with an X by the accused petitioner is also inconsistent with the medical evidence of PW5, the doctor, who has clearly opined that PW1 was injured with a blunt object He accordingly submits that the conviction is totally erroneous in law and is liable to be set aside. He further submits that the trial court ought to have given the benefit of probation of offenders act, considering the nature of allegation and also the fact that he is a student, and moreover there is no criminal antecedent. Hence, no, full stop. He further submits that the 6 months sentence is excessive, and the same may be alternatively, that this is excessive and the same may be adequately reduced. Stop. এই যে সাবমিশনস খিনি আপুনি গ্ৰাউণ্ডছত আছে 7 of 10 অকমান তাৰ পৰা চাই ল'ব লাগে per contra, MS Begum so and so submits that both the trial court and the appellate court has properly assessed and analyzed the evidence on record and has recorded of the finding of guilt against the accused petitioner. Hence, the impugned judgment in order of the trial court and the appellate court warrants no interference by the revisional court, by this revisional court. Stop. She further submits that neither the trial court nor the appellate court has committed any manifest irregularity or illegality in convicting the accused petitioner for the offense under section 354 IPC. Sorry, 325. I'm still in the earlier case. 325 IPC. She further submits that the testimony of the eyewitness of the injured witness as IPW1 is corroborated with the other materials, including the medical evidence. Stop. I think that's all. Episode. Third perused hini didiva margineke due. Yat apunita. It appears it appears that PW1 so and so, i.e. the informant come victim, deposed. Like 4, that was an in cross depose yate ase. Paragraph 4, page 4 at pabo. Paragraph 5, similarly, PW2 so and so deposed. ঠিক আছে? PW তাতে cross 2 আছে নি? তাৰপিছত 3, তাৰপিছত 4, then 5, then 6. It appears that after completion of the prosecution witness, all the incriminating circumstances were put to the accused petitioner under section 313 of the CRPC, wherein he merely denied the same and adduced did not adduce any evidence whatsoever. Stop. Reading of the aforesaid evidence, it is this we will last or line 2 backwards. Reading the efforts of the court. Upon careful examination of the evidence and the findings recorded by the trial court as well as the appellate court, it appears that the testimony of the injured informant, who had no reason to falsely implicate the accused petitioner, accused petitioner, has been found consistent and natural. His statement that the accused petitioner dealt a blow with an X on his left hand finds due corroboration from the medical evidence showing a lacerated injury and a fracture, which are consistent with a blow by a blunt portion of a weapon like an X. The fact, the fact that the weapon was not, the said weapon was not recovered does not, in the facts of the case, create any reasonable doubt when the direct testimony of the injured witness stands corroborated by medical evidence and the attending circumstances. The other witnesses, though not eyewitnesses to the assault, have corroborated the immediate aftermath and presence of both parties at the place of occurrence. Correct? Lending assurance to the prosecution case. Stop. It is well settled that the revisional jurisdiction under section 397 and 401 of CRPC is limited. This court cannot reappreciate evidence as a third court of fact unless there is manifest illegality, perversity, or miscarriage of justice. Very fast question. Upon perusal of the record, no such infirmity or illegality is found in the concurrent findings of conviction recorded by the first two courts. First two court is correct. Now we can use first two courts. Upon perusal if you pour a sentence to upon careful it highlight it change I think dubar koloni upon perusal. As regards the sentence, the petitioner has been sentenced to undergo 6 months, 6 months simple imprisonment for the offense under section 325 IPC, which prescribes maximum punishment of 7 years. Full stop. Considering the nature of the injury, the weapon used, and the circumstances of the occurrence, the sentence imposed cannot be said to be excessive or disproportionate. Stop. For the foregoing reasons, change the para. This court finds no illegality or, impropriety or perversity in the impugned judgments warranting interference in revisional jurisdiction. Stop. The criminal revision petition is therefore dismissed. The conviction and sentence of the petitioner under section 325 IPC as recorded by the courts, by the two courts, are hereby affirmed. The petitioner shall surrender to serve the remaining sentence, if any, because he was out only, no? I think I should indicate that if any,
If any, Lordship.
if any, ordered accordingly. Sorry,
Lordship.
return TCR. TCR আহিছে নে?
I,
দি দিয়ক বাইদেউ, return TCR.
Item 5.
Yes, look it up. None appears for the appellant on call. Mr. B. Sharma, learned APP is present, relist after a week on a date to be fixed by the registry.
Item number 8.
None appears for the petitioner on call, for the parties on call, relist after a week on a date to be fixed by the registry.
Item number 9.
Same.
Item 10.
Same.
Item 11.
Yes, Mr. Hajorika,
Please, Your Lordship.
you are arguing or you want Mr. Mr. Roy to be called? I saw you indicating something to your junior. Yes. What is this revision petition?
My lord, rash and negligent driving, my lord.
Rash and
Negligent
negligent
driving, my
driving.
lord. My lord, concurrent finding of two courts, my lord. 6 month punishment under 304.
6 months.
Yes, my lord.
Why all punishments that are coming as 6 months?
My lord.
Yes. 6 months, yes.
In the 6 months. Other also, my lord, 1,000 fine under 279.
Okay.
338 or 1,000 fine, and under 427, 10,000 fine, my lord.
Is your 4 a.m.
304 and 2 years.
So this section is
279.
okay, then change code operator. So you both are ready for hearing, na? Section
279,
yes,
338,
yes,
304A,
304A
427.
427. আপনি যোগ এতিয়া কাৰণ আহিব নালাগে কৈ দিয়ক না পকক এইফাল দি দিয়ক and 6 months na
No, 6 months. Under
It was
304A, 6 months.
appellate court, my lord, reduced to 6
Reduced,
months.
modified the order.
Earlier, my lord, 2 years was given. And
so the trial court gave 2 years
2 years.
Maximum punishment.
Then,
2 years
then it was
and this was under 304 capital A
304 capital A. And reduced to 6 months.
okay yes what is the illegality that has been committed
Well, on the basis of-
revision jurisdiction
304, my lord, sorry, my lord, on the basis of PW4, my lord, all conviction was given, my lord.
but there is evidence is it a case of no evidence
My lord,
Yes, ma'am, because
yes there is concurrent
concurrent
finding
finding, my lord, concurrent finding, and also the here, my lord, PW4, if you losses may allow me, my lord. May losses, my lord. PW4, my lord, he happens to be the eyewitness of the accident, my lord. And
Mhm.
when he saw the incident, according to him, the bus, my lord, in a very negligent way, it came to the wrong side of the, while overtaking another vehicle, man. It came to the wrong side of the side, my lord, and that's the.
Colluded.
Yes, and magic, and that is the, and
All right, if I have to author the judgment, then probably I'll have to see the facts a bit. You want,
Fix any other.
huh?
We fix any other.
Why? What is there? There is nothing. I'll dismiss it.
No, no.
I don't see anything. Huh, Mr. Hajorika? Where is the material illegality? Where is the perversity?
PW4 said, my lord, he has seen the incident. By 150 meters distance, he has seen the incident. My lord. And my lord, he has
But
admitted.
you see, that's why I'm repeating myself. This is the revisional court. Both courts have appreciated the evidence and recorded the conviction.
This.
What is the jurisdictional error? This is a 2014 matter. 6 months, probably you are still outside.
he's outside.
So you be inside for 6 months and then everything will end.
Fix after 1 week.
No, I am not adjourning this matter. What is that to adjourn? And I've already given some time, and at 3, the courts will anyway, at 3:15, I think the courts are rising
No.
because there is a full court. By then I can finish it, clear this judgment.
No.
No, I'm not. Unless you convince me that you have a case, then of course I'll give it in your favor. But let's read. Let's read together. You see, Mr. Hajorika, neither you can change the records, facts, nor can I. We'll have to go by the record. Let us see the judgments one. Where is the trial court judgment?
Start from page number 12, my lord.
Yes. Hmm?
Yeah.
Yes, Mr. Hajorika.
Decision start from page number 13, my lord.
Yes. 1 second, the prosecution, just read because I'll have to see, I'm going to dictate immediately. So unless I consume the facts, it becomes difficult. So you read, you place paragraph page 12 starts, sir. The prosecution case in brief.
Prosecution case in brief is that on 21/8/2011 at about so and so, the accused being the driver of the offending vehicle, namely city bus, bearing number so and so, driving the vehicle in high speed negligently on the ill-fated day, had hit one Tata S bearing license number so and so, coming from the opposite direction, causing damage to the vehicle as well as causing death to the complainant's brother and injure the other co-passenger. He is driver of the Tata Ace, my lord, and accused is the driver of the
Offending vehicle.
my lord.
City bus.
City bus, my lord.
City
City
City ride, my lord.
Yes, city bus, a bus.
City bus.
It's a bus.
In record, my lord, city ride, my lord.
Okay. So the accused, the convict is of the bus,
Must bus.
and the passenger was in
In the magic,
My lord, victim, my lord, Tata Ace, my lord.
Tata Ace is that magic.
magic.
Magic, my lord, Tata Magic.
The victim, the complainant was from in that.
Complaint is the brother of the
Complaint
victim,
brother
my
of the
lord.
deceased, my lord.
This is.
Or deceased.
Yes, my lord.
Deceased, brother of the
Very well. Yes.
Court take cognizance of the offense, issue, process the cause of the offense. The case, copies of the furnished to him, it appears upon consideration of relevant materials on record, hearing the parties are charged under 279, 338, 304, capital A, 427 was found against him, and the same is read over and explained to him, which he pleaded not guilty and claimed to be tried. Trial mode. After framing the charges, prosecution examined as many 13 witnesses. Defense plea was total denial. Defense adduced no evidence. In this case, the point of determination are whether the accused was driving the offending vehicle bearing license number so and so on the ill-fated date at the time of the occurrence. If no, whether he is driving the vehicle in a reckless negligent manner, thereby knocked the Tata Ace bearing license number so coming from the opposite direction, causing death of the complainant's brother and injured the other co-passenger to damage Tata Ace. Heard and consent of the both the sides and statement of the 130 will be recorded. Pleading innocence, framed the CC.
PW4 have seen.
You
My
have
lord,
rep sheet,
my
my
lord.
lord.
On the basis of PW4, my lord, entire my lord, conviction was granted, my lord.
And he was not cross-examined.
My lord, cross-examined, my
Cross-examined,
lord.
but it's.
He has, my lord,
unchecked.
cross-examined admitted that both vehicle in high speed, my lord. And he,
No, witness is not examined by defense during
no,
cross-examination.
no, it is wrongly observed, my lord.
So this has been proved that you were driving the vehicle.
My lord, we have denied in 13.
So,
My lord.
so that is at the last stage. Have you ever taken this plea earlier point of time?
I have none.
Yeah.
taken.
313 is at the end after every. You had your chance to cross-examine. During cross-examination, did you lay any foundation for this court to? Because I understand that you don't have to prove beyond reasonable doubt, but
Yes.
nonetheless, you have to probabilize your defense. So where did you probabilize? After everything was closed in 313, then how can that be?
All
And no adduced, have you adduced any evidence to show you or at that moment you were driving some other vehicle or something else?
Only 313, my lord, I have stated this.
That is anyway a factual aspect.
My lord.
This court is not going to that.
My lord.
Yes.
Before discussion, so second clear. So only point out whether the accused is driving the offending vehicle in a recent negligent manner. Though initially the accused did not took the plea, he was not driving the vehicle on the ill-fated date at the time of the incident, but at the examination 313 statement, he took the plea that he is not driving the vehicle on the ill-fated day, whether it was driven by the Raju. As per the instruction of the owner of the bus, he had only accompanied him only. So the first point of determination was framed in this case. As regard to point number 1 determinations, if we see the version of the PW 13, we could find that the accused himself surrendered before him, and he was arrested in connection with the incident. Further, his version also
It's okay, it's okay. Go on, go on.
revealed that he had seized the driving license of the accused on being produced from the owner of the offending vehicle. That apart, PW4, who is the owner of the dhaba near PO, place of occurrence, and who is an independent eyewitness, also claimed to have been witness occurrence and accused driving the offending vehicle on ill-fated date. Witness is not examined by defense during the cross-examination. Now it is clear that the accused was driving that vehicle on that so who is his
So here for 304 capital A, the maximum is how much?
2 years.
2 years. The appellate court has already brought it, reduced it to 6 months. What about
Or
the
fine,
other sections?
My lord,
They were not proved.
279, 1,000 fine, my lord, 1,000 fine, my lord. And that
So what was proved? Let's see. Thus from above, I'm constrained to hold that accused is guilty on 279, 338, 304 capital A and 427 and convicted. Taking into consideration he is not given the benefit of section so and so. Charges and accused sentenced to pay when so in the first and so and so and so. That's really bad.
page number 15, my lord.
And the appellate court, 21.
Start from 31, my lord.
31, yes.
31. The PW1, the informant, my lord, stated about the PW1. PW2, my lord, page number 34, my lord.
Is that the same?
My lord, same, my lord.
Those are those
So
same.
3, my lord, they have not changed, my lord.
Basically, 1, 2, no, 2 and 3 were injured.
Injured, my lord.
4 is an independent eyewitness,
man.
and he has seen the
On the
accused.
basis of his, my lord, statement, my lord.
What do you mean on the basis of that one eyewitness is good enough? You don't need 2 eyewitness.
My lord,
Huh? There is nothing that to shake his way of testimony,
contradiction is
Mr.
there, my lord.
Achorika.
my lord, some contradiction.
Sorry, Mr. Achorika, you have no case.
My lord, kindly see, my lord, PW1 and 2 said that.
That's
what-
factual error, jurisdictional error. I'm repeating again.
And on the court judgment, man, not interpreted, rightly interpreted the PW4, man, statement of the PW4, man.
Okay, I have noted your argument. I'll deal with it. More. What else? Anything else?
Man, main
Yes,
It was
main,
stated by the PW 1 and 2, my lord, that when I overtake the vehicle 709 man, then my accident was occurred, my lord.
okay, okay.
You know, PW, my lord, 4 stated that, my lord, that no overtaking was there directly wrong side. Head in collision
Relax,
with
you
the,
say it properly. I'm hearing you.
my lord, head in collision with the offending vehicle, my lord. My lord,
Let's see where that is. You, Mr. Goswami, you have the trial court? Okay, you can read, Mr. Hajorka. If you have it, just read 1, 2, 3, and 4 once.
my lord.
আগতে মাতি দিলো ৰবা কৰি আছা নেকি yes
PW 1, my lord.
just read it
মই গুচৰীয়া মৃত পবিত্ৰ গগৈ মোৰ দাদা হয় আমাৰ ওচৰৰে আৰু জখমী দিব
one is not an eyewitness
2 and 3 man
go to 2 and 3 I think
2 and 3
key
is a-
witness are 2 3 4
Yes.
and 13
my lord.
Yes.
because he surrendered also
He surrendered also.
his license was also taken there
That is what has been said that 313 is not.
I've
Second.
seen Mr. Goswami
গুচৰীয়াক মই চিনি পাওঁ
but Mr. Hajorika should be also fully satisfied that he has been heard properly by this court.
accidental case so my
Yes.
that may be considered that গুচৰীয়াক মই চিনি পাওঁ একে গাঁৱৰ আছামিক মই চিনি নাপাওঁ 2011 চনৰ দিনত
These are reading 2.
my lord,
PW2.
my lord.
Yes, yes.
প্ৰায় 3 মান বজাত মই পৰা তিয়কৰ পৰা শিৱসাগৰলৈ জাজিলৈ গৈ আছিলো মোৰ ভাইটিৰ বৰদেউতাৰ ল'ৰা প্ৰাঞ্জল দুৱাৰাও মোৰ লগত আছিল আমি গাড়ীত বহি গৈছিলো পাছফালে বহি গৈছিলো পবিত্ৰ গগৈয়ে চলাই গৈছিল এই এক্সিডেণ্টত তেওঁ ঢুকালে জাজি তিনিআলি পাৰ হৈ নেশ্যনেল হাইৱেত নিজৰ ছাইডত গৈ থাকোঁতে এখন 709 বাছ পায়
That is the offending.
No,
Huh?
they another vehicle.
Oh, that is
They
another.
said my
Okay.
পায় আমাৰ বিপৰীত ফালৰ পৰা আহি আছিল
Bipod means opposite.
opposite তাৰ পিছে দুৰ্ঘটনা কৰা চিটি ৰাইড বাছখন আহি আছিল জোৰত
That was coming
Opposite.
behind that
opposite side.
the other car behind the 709. Yes.
709 বাছখন আমাক দৰে হৈ গ'ল
আমাক পাৰ হৈ গ'ল
আমাক পাৰ হৈ গ'ল সেই সময়তে জোৰত অহা চিটি ৰাইড বাছখনে অভাৰটেক কৰিবলৈ যোৱাত এইফালে চলাই আহি আমাক সন্মুখৰ পৰা খুন্দা মাৰি দিয়ে চিটি ৰাইডখনে 709 ফলত কম্পিটিশ্যন কৰি আছিলে অভাৰটেকিং কৰিবলৈ স্পীডটো দেখি জানিব পাৰো জানিব পাৰো খুন্দা মৰাৰ পিছত মই চেঞ্চলেট হৈ যাওঁ হেডলাইট পোহৰ দিয়া গম পাওঁ চেঞ্চ আহোঁতে মই তিয়ক হস্পিটেলত আছিলোঁ মই কঁকালত দুখ পাইছিলোঁ মোৰ হাতত
That's okay. That's all right.
টেক্স মানে মই ভাইটি প্ৰাঞ্জলৰ বাবে দুখ পালোঁ মূৰত দুখ পালোঁ এতিয়া ভাল হোৱা নাই
That part may not be required. Yes.
আমি ওচৰত কোনো দোকান পোহাৰ দেখা নাছিলোঁ দোকান বজাৰ দেখা নাছিলোঁ গধূলি আছিল
That's all right. I don't think they have so much of relevance.
709 আৰু চিটি ৰাইড আৰু বিপৰীত দিশৰ পৰা আহি আছিল 709খন আমাক পাৰ হৈ গুচি গ'ল
Now, which is you are the driver of which one?
চিটি ৰাইড
So 709
Which
and
one?
city ride.
my two vehicles
They were coming from behind.
opposite side
Both opposite side.
both
So the first was the 709 and the one behind was
Yes.
that.
my city right
So what is that? Your is city ride.
City ride.
City ride. It is what type of a vehicle?
It is like a
City bus, my lord.
bus, my lord,
So-
that not the big bus, my lord.
Smaller bus.
Smaller bus,
Mini
my
bus.
Mini bus.
mini bus
Okay. So, and they both were doing competitions.
Competition
As per their statement.
and
Competition.
And the 709 crossed,
cross,
Cross my
and then this hit you.
this hit you.
Correct. This is
Right.
how it has
This
been
is-
narrated.
as per competition, they.
Correct, correct. This is what has been proposed by PW2.
Yes.
That those two were,
Yes.
while they were competing with one another at the time of crossing, after 709 passed crossed you,
Hmm.
the one which was driven by the, allegedly driven by you,
Yes.
that vehicle hit.
Hit.
And then the accident took place, where the deceased, the complainant's brother died. Correct.
At the hospital, man.
At the hospital.
Man.
সেইকেইটাৰ নামকেইটা, Yes. And
And
you were in what car? Which car were you driving?
City ride, man. Second,
You are, no, you are driving that city, right?
yes, man. City ride, man.
Okay.
Second
No, no.
vehicle, man.
No, occupant. PW2.
Oh, you were
PW2.
that vehicle, sorry,
PW2 is the occupant of the Tata Magic.
Tata Magic, man.
that's a different one.
No, that who is heated, my lord. The Tata Magic, my lord. Where the
You're confusing me now. PW2 was traveling in a vehicle which was coming from the other side, because these two cars were coming from the opposite side.
real person in
Institute, man.
the
Acha, acha, acha,
Magic,
acha,
my
acha.
lord. Not only one, my
Okay, the deceased was in another car.
lord. Disease was also there.
In which
along-
car?
In Magic.
Magic, my along with him, PW2 is also.
And Magic was driven by whom?
My disease, man.
Deceased.
Deceased.
My lord.
Okay.
And PW.
And both bus will come from
Over-
opposite side. Both
opposite
parts.
side. And they were competing with one
My
another.
lord.
Okay, understood.
গুচি গ'ল চিটি ৰাইডখনে 709 খনক অভাৰটেক কৰি পাৰ হৈ গুচি যায় বুলি ভাবিছিলো, কিন্তু আমাকহে খুন্দিয়াই গুচি যায়।
Yes.
In this মানে জাংচাৰ মানে accident took place as per his
Okay.
statement, মানে
Yes.
এটা টাইম অভাৰটেকিং মানে আমি লৈ ফালৰ পৰা গৈ আছো, আমি শিৱসাগৰ ফাললৈ গৈ আছিলো, আৰু 709 আৰু চিটি ৰাইড দুখন শিৱসাগৰৰ পৰা তিয়কৰ অভিমুখে আহি আছিল। আমাৰ টাটা মেজিকখন ফালে মাল কঢ়িওৱা গাড়ী, পেচেঞ্জাৰ কেৰিং ভেহিকল নহয়। টাটা মেজিকখনত পিছফালে মই 25 কেজি কইল কঢ়িয়াই লৈ আনিছিলো। আমি তিনিজনে ড্ৰাইভাৰৰ ওচৰতে বহি আছিলো। আনফালে সন্মুখত মানুহ বহিবলৈ 3 চেম্বাৰ আছে। আমি তেনেকৈ বহি গৈছিলো। ড্ৰাইভাৰৰ গাত বহি যোৱা নাই। মেজিক গাড়ীত আমাৰ দুটা আৰু পিছফালে দুটা চকা থাকে। সত্য নহয় যে আমাৰ গাড়ী চালকে চাইচোন মাইলত, সত্য নহয় যে আমাৰ গাড়ী চালকে মদ খাই গাড়ী চলাই নিজে
This is the Magic.
মেজিক মাইলত চাইচোন মানে মেজিক গাড়ী খুন্দিয়াই এক্সিডেণ্টটো কৰা। সত্য নহয় যে চিটি ৰাইডখনত অসাৱধানভাৱে আমাক মৰা নাই। চিটি ৰাইডখনে আমাক চাইডত মাৰিছে, আমাক ৰং চাইডত মাৰিছে। শুদ্ধ নহয় মানে PW3 মানে গুচৰীয়াক চিনি নাপাওঁ, আছামিক চিনি নাপাওঁ,
P was in which vehicle? Same vehicle.
Magic.
Okay.
চিনি নাপাওঁ, আছামিক চিনি নাপাওঁ। জখম দীপক দুৱাৰা PW1 হয়। 2011 চনৰ এক্সিডেণ্টটো হৈছিল।
Same,
মানে চেম মানে ষ্টেটমেণ্ট। মেজিকত গৈ আছিলো, কঢ়িওৱা গাড়ী, দাদা আৰু মই ড্ৰাইভাৰৰ পিছ চাইডত বহি আছিলো। ড্ৰাইভাৰ আছিল মৃত পবিত্ৰ গগৈ। গাড়ীখন তেওঁৰ আছিল, তেওঁৰ আমাৰ চিনাকি।
Pavitra Gogoi was not convicted.
No.
ডিজিজ মানে
Oh, he died.
হি ডাইড মানে হি মেজিক মানে হি ডাইড মানে
Correct. Sorry.
Driver.
Yes.
আমাৰ বিপৰীত ফালৰ পৰা অহা 609 আৰু 709 বাছ এখন আহি আছিল। তাৰ পিছফালে চিটি ৰাইড বাছখন আহি আছিল, খুব স্পীডত আহিছিল। চিটি ৰাইডখনে সেই বাছখনক অভাৰটেক কৰিবলৈ গৈ আমাক জোৰত খুন্দিয়াই দিয়ে। মই লগে লগে বেহুচ হৈ যাওঁ। মই 6 দিনৰ পিছত হোচ পাওঁ। মই যেতিয়া জানিব পাৰোঁ যে মই সঞ্জীৱনী হস্পিটেল ডিব্ৰুগড়ত আছো। মই মূৰত আৰু সোঁহাতত জখম পাওঁ। মই বুকুতো দুখ পাওঁ। এমাহ মানৰ পিছত জানিব পাৰোঁ যে পবিত্ৰৰ মৃত্যু হয়। জখম পাইছো। বৰ্তমান নোৱাৰো, কাম কৰোঁতে কষ্ট হয়। ক্ৰছ এক্সামিনেশ্যন মানে টাটা মেজিক গাড়ীখনত টাটা এজ বুলি কয়। টাটা মেজিক গাড়ীখন টাটা এজ বুলি কয় আমি টাটা এজ গাড়ীত আছিলোঁ সত্য নহয় যে বিপৰীত দিশৰ পৰা অহা গাড়ীখনে চিটি ৰাইডখন আছিল যে তাৰ এখন 709 বা 609 বাছ নহয় সত্য নহয় যে আমাৰ ড্ৰাইভাৰে মদ খাই নিয়ন্ত্ৰণ হেৰুৱাই অসাৱধান হৈ পেলাই নিজৰ গাড়ীখন খুন্দা মাৰে
So in cross, every time, this is what you're trying to suggest, that was
his fault my lord.
his
His
fault.
fault, my lord.
But nowhere you said that, no suggestion that you were not driving the
No,
vehicle.
no.
Yes, yes, go on.
PW4 মানে very important.
Your key witness.
Yes.
Key witness, ma'am.
Not my PW. আসামিক এক্সিডেণ্টৰ সময়ত দেখিছিলোঁ ঘটনাস্থলী
Assamit accidentor সময়ত দেখিছিলো. Yes.
দেখিছিলোঁ ঘটনাস্থলী আপোনাৰ হাঁহচৰা নেশ্যনেল হাইৱে গুচৰীয়াক চিনি নাপাওঁ মৃত পবিত্ৰ গগৈক চিনি পাওঁ তাক চিনি পায় দিছ ইজ নন টু হিম মেজিক এখনৰ ড্ৰাইভাৰ হিচাপে 2011 চনত এদিন 4টামান বজাত এক্সিডেণ্টটো হৈছিল মই প্লেচ অফ অকাৰেঞ্চৰ ওচৰতে থকা মোৰ ধাবাৰ বাহিৰত ৰৈ আছিলোঁ পবিত্ৰ গগৈয়ে মেজিকখন যোৰহাটৰ ফালৰ পৰা শিৱসাগৰ ফাললৈ গৈ আছিল চিটি ৰাইডখন বিপৰীত ফালৰ পৰা আহি আছিল মই ঘটনাটো দেখি আছিলোঁ মেজিকখন নিজৰ ছাইডতে আছিল চিটি ৰাইডখন স্পীডত ৰং ছাইডৰ পৰা আহি মুখামুখি মেজিকখনক খুন্দা মাৰে ইন হিজ ষ্টেটমেণ্ট মাই লৰ্ড নো কম্পিটিশ্যন অৰ মাই লৰ্ড
It's okay, right. Read, sorry.
তেতিয়া দুইখন গাড়ী ৰৈ গ'ল দুইখন গাড়ী ডেমেজ হ'ল মানুহ জখম হৈছিল মই ওচৰলৈ গৈ পবিত্ৰ গগৈক দেখাই পাই চিনি পাওঁ তেওঁ গাড়ীৰ ভিতৰৰ পৰা উলিয়াই নি হস্পিটেললৈ পঠোৱা হয় মেজিকত থকা আৰু দুজন ব্যক্তি জখম হয় তেওঁলোকক হস্পিটেললৈ পঠোৱা হয় আসামিক মই তেতিয়া চিটি ৰাইডখনতে দেখিছিলোঁ সেইখন তেওঁ চলাই আহিছিল তেওঁ জখম পোৱা নাছিল পবিত্ৰ পুলিচ আহিল গাড়ী দুখন লৈ গ'ল ক্ৰছ এক্সামিনেশ্যন মাৰিলোঁ মই ধাবাখনৰ কাষত ওচৰত ৰৈ থকা জেগাৰ পৰা প্ৰায় ঘটনাৰ পৰা 150
This is cross.
মিটাৰ
This is cross.
150 meters.
150 মিটাৰটো এবিট আছিলে মানে আৰু ধাবাত আছিলে
In front of the dhaba.
150 meters.
150 মানে
Very less.
নাই
All right, Mr. Hajorika.
সেই সময়ত মোৰ ধাবাত প্ৰায় 30 জন মান কাষ্টমাৰ আছিল আৰু মোৰ 8 জন এমপ্লয়ী আছিল মেজিক গাড়ীখনত গুড কেৰিয়াৰ গাড়ী আছিল মেজিক গাড়ীখনত
Magic গাড়ীখনত?
মানে গুড কেৰিয়াৰ্ছ মানে
Okay.
গুড কেৰিয়াৰ্ছ মেজিক গাড়ীখনত ড্ৰাইভাৰ চিটত লগত পিছফালে দুজন মানুহ বহি যাব পৰা চিট থাকে মেজিক গাড়ীখন বস্তু লৈ গৈছিল আৰু তাত আৰু কোনো বেলেগ চিটি ৰাইড বা পেচেঞ্জাৰ নমাই থকা মানে দিছ ইজ ইণ্টাৰেষ্টিং মানে তাত আৰু কোনো বেলেগ চিটি ৰাইড বা পেচেঞ্জাৰ নমাই থকা নাছিল 300 মিটাৰ্ছ আঁতৰত এখন 708 গাড়ী ৰখাই থোৱা আছিল
কিমান মিটাৰ?
300 মিটাৰ আকৌ মাইলত পেচেঞ্জাৰ গাড়ীখন থকা নাছিল 300 মিটাৰ আঁতৰত এখন 709 বাছ ৰখাই থোৱা আছিল এই এক্সিডেণ্টৰ লগত সেই বাছখনৰ কোনো সম্পৰ্ক নাই মানে
বুজিলো. The one which was stopped, which was parked about 300 meters, has nothing to do with the accident.
However, 1 and 2 has stated matter differently, man.
Anyway, read. See, Mr. Hajorika, you have to also appreciate factual. I'm only trying to find out if there is any jurisdictional error. I'm not seeing anything till now. Anyway, you finish it.
Then হোৱাৰ পিছত দুইখন গাড়ী তাতে ৰৈ গ'ল 3জন জখমৰ ভিতৰত মেজিকৰ ভিতৰত এজন জখম ওলাই গ'ল দুজনৰ অন্য জখম ড্ৰাইভাৰৰ লগত আছিল মেজিকখন মই এফাৰ্ট বাহিৰত আছিলোঁ চাই আছিলোঁ ৰাস্তাৰ কাষত তেতিয়া এক্সিডেণ্টটো হৈছিল চিটি ৰাইডখন আছিল আৰু 8জন মান মানুহ আছিলে লাষ্টত ছাজেশ্যন মাৰিলোঁ ছাজেশ্যন পাৰ্ট সত্য নহয় যে মেজিকৰ ড্ৰাইভাৰজন মদ খাই
The same suggestion.
চেম ছাজেশ্যন মাৰিলোঁ মেজিকৰ ড্ৰাইভাৰে
All right.
সিধাকে
Okay, I have to dictate judgment also.
গাড়ীখন
The same thing, don't now repeat.
দুইখন গাড়ী মানে ইণ্টাৰেষ্টিং মানে
Yes, yes.
দুইখন গাড়ী স্পীডত আছিল ইজ এডমিটেড মানে সত্য নহয় যে মেজিকৰ গাড়ীখনৰ স্পীডত চিটি ৰাইডখন খুন্দা মাৰে
And 13, PW 13, IO na?
মানে আৰু
Let's see the IO one.
যোৱা 21/2/2011 তাৰিখে 3:25 মই টিয়ক থানাত এটাচ অফিচাৰ হিচাপে থাকোঁতে এজন লোকে থানাত জনাই যে হাঁহচৰত এটা গাড়ীৰ এক্সিডেণ্ট হৈছে উক্ত ঘটনাৰ সংবাদ পাই OC GTND 409 দৰজ কৰি আৰু মোক ঘটনাস্থলীলৈ যাবলৈ নিৰ্দেশ দিয়ে মই লগে লগে প্লেচ অফ অকাৰেঞ্চলৈ ৰাওনা হওঁ ঘটনাস্থলীটো NH 37
Just see somewhere he has said about the accused surrendering. Which is that part? Just read that, please. Mr. Goswami?
Yes, my in that
Just read out that portion, please. The other things are not in dispute.
চিটি ৰাইডখন চলাওঁতে শিৱসাগৰৰ পৰা যোৱা ৰবীন্দ্ৰ টিকটি গৈছিল অন্য এখন চিটি ৰাইড ৰখাই থোৱা পাছত
Item number to Jana.
exhibit 3
Oh.
from
Exhibit 3 PM ৰিপৰ্টখন মই তদন্তকাল সংগ্ৰহ কৰোঁ 23/8/2011 তাৰিখে চিটি ৰাইডৰ বাছৰ চালক ধ্ৰুৱজ্যোতি বৰাই থানাত আহি আত্মসমৰ্পণ কৰে
Okay.
তেওঁ সোধপোছ
Okay.
কৰি এৰেষ্ট কৰা
All right, Mr. Hajorika. Yes, take down. Heard Mr. R. Hajorika.
See one paragraph which may
Huh?
in the appeal manner para 24 regarding the yardsticks for convicting under 304A minor that has been discussed in that, so it may be helpful. Para 24 of the appellate judgment note. Perhaps.
24 no judgment
In the my affiliate judgment.
Yes.
Para 24.
Take Kadir.
Yes, my lord. That is very important. But it says, my lord, may I read, my lord? Just one paragraph. only.
Yes. You don't want the judgment today?
No, my lord, just because that is.
You want it or no?
Yeah, no. Lords, yes, my lord.
Where is the time? Let me dictate.
No, only 2 lines. Your lordship can see.
I will indicate it. That time you point out this
Yes.
is some apex court judgment that has been
Yes,
quoted in the
yes,
appellate court. Yeah.
Yes, that is what.
I'm not even finding any case. There is no perversity, material illegality.
No,
Why do this court needs to now record the judgments?
no,
Huh? Where is it? Do you where is the material irregularity? Or there is something that you're not saying it to the court that you are at a defensive.
no, no.
41 minor
Yes,
23 minor
yes.
Set about case minor kindly peruse my-
That is all factual, Mr. Hajorika. Why is it important? What is the importance? The eyewitnesses are there. PW4 has identified you.
Yes, ma'am.
PW4 has is an independent witness.
Recent
That apart, PW2 and 3 is there.
recent negligence need to be proved my lord
It has said. And this is also the
Both
evidence of other PWs, though found to be not material to prove the rash and negligent driving of city ride vehicle, yet their evidence also confirms the head-on collision between the two vehicles involved in the accident. I don't find these are factual finding.
my lord
I don't see any jurisdictional error in this. It could have been completely different if it was a case of no evidence at all. Now, how do I go into the sufficiency of evidence in the revisional jurisdiction? Please tell me.
It's a material
Okay.
contradiction my lord about the incident my lord and my recent negligence
I will note down
Right.
that anyway. Heard ki likhila? Namdillah.
he has
Also,
also suffered my 14 years my lord
all right. The present revision petition is directed against the judgment and order dated 9/9/2014 passed by the learned session judge Jorhat in criminal appeal number 20 of 2014, whereby the appeal filed by the accused petitioner was partly allowed and the sentence of 2 years simple imprisonment under section 304 within bracket capital A of the of IPC as has been awarded by judgment dated 12/3/2014 in GR case number 1253 of 2011 by the Subdivisional Judicial Magistrate Jorhat has been modified to simple imprisonment for a period of 6 months with a fine of rupees 5,000 in default of payment of fine to undergo simple imprisonment for another 45 days. The case of the prosecution in brief is that the informant PW1 lodged an FIR before TIOC PS on 24/8/2011 to the effect that on 21/8/2011 at about 4 p.m. his elder brother Pobitro Gogoi, hereinafter referred to as the deceased, while was driving his Tata AC vehicle bearing registration number AS04 AC/0814 from TIOC to Sipsagar side, and upon reaching near Blue Heaven Dhaba, situated near Jhanji Chora, TIOC, on the National Highway 37, one city bus vehicle bearing registration number AS03E0155, which was coming from the opposite direction, being driven by its driver, in a rash and negligent manner, knocked down the vehicle of knocked down the said Tata AC vehicle. For which the deceased received grievous injury on his person and later on succumbed to his injuries at the Jorhat Medical College and Hospital. It is the further case of the prosecution that other passengers who were traveling in the other vehicle, i.e. Tata AC, also received in the other vehicle, in the said vehicle, also received grievous injuries on their person, and they were also examined at TIOC FRU. It is the further allegation of the prosecution that the accused petitioner drove the city bus vehicle rashly and negligently, and the accident occurred due to his rash and negligent act of driving. Accordingly, a case was registered under section 279/304 capital A/427/338 IPC. Upon completion of investigation, charge sheet was submitted. Thereafter, trial commenced, wherein the accused plead not guilty. Accused petitioner. During the trial, in order to prove its case, the prosecution examined altogether 13 witnesses. Upon conclusion of the trial court found the accused guilty under section 279/304 capital A/427/338 IPC and sentenced accordingly. being aggrieved an appeal being criminal appeal number 20/2014 was preferred before the appellate court. And the appellate court, after reappreciating and analyzing the evidence, though did not upheld the conviction. Was pleased to upheld the conviction. However, reduced the sentence of 2 years simple imprisonment under section 304 capital A of IPC awarded by the trial court to simple imprisonment for a period of 6 months with a fine of rupees 5,000 in default of payment of fine to undergo simple imprisonment for another 45 days. Stop. Situated thus the present revision petition. Mr. Hajorika submits that there has been the evidence on record does not warrant conviction of the petitioner, and both the two courts erred in law and facts in convicting the accused petitioner. Stop. He further submits that the two courts failed to note the serious contradictions in the evidence of the prosecution witnesses, and as such, the impugned conviction is liable to be set aside. He further submits that the two courts committed serious error of law and facts in brushing aside the serious discrepancies in the evidence of the prosecution witnesses. He further submits that the accused petitioner has not been identified by the PWs as driver of the alleged offending vehicle, within brackets City Rider, and the rash and negligent driving of the accused petitioner has not been proved. He further submits that the PW6 deposed in his evidence that he has not mentioned the injuries in medical report. He further submits that there is no material under sections 279, 304 capital A, 427, 338 IPC against the petitioner accused, and hence the conviction is not sustainable in the eye of law. Stop. Per contra, Mr. MP Goswami, learned APP, submits that supports the impugned judgments and submits that the injured witness's testimony and the testimony of the independent eyewitness are cogent and trustworthy, duly supported by surrounding circumstances, and that both the two courts have concurrently recorded well-reasoned findings based on evidence. That's all.
Yes.
It appears that I heard perused subdivision. It appears that the trial court and the appellate court, upon appreciation of the evidence of the two injured witnesses, PW 2 and 3, and the eyewitness, PW 4, have found the prosecution and other witnesses have found the prosecution version to be established beyond reasonable doubt. The testimony of the independent eyewitness PW 4, who had no reasons to falsely implicate the petitioner accused, has been found convincing and natural. His statement that where did he say? He said that no, it wasn't cross. He have clearly said that the accused petitioner was driving. His statement, his statement to the effect that the accused petitioner was driving the vehicle on that date, on the day of occurrence, is clearly established. It is well settled that the revisional jurisdiction under Section 397 and 401 CRPC is limited. This court cannot reappreciate evidence as a third court of facts unless there is manifest illegality, perversity, or miscarriage of justice. Stop. Upon careful perusal of the record, no such infirmity or illegality is found in the concurrent findings recorded by the two courts. As regards the sentence, it appears that though initially the trial court had sentenced the accused petitioner to undergo 2 years rigorous simple imprisonment for the offense under Section 304 capital A. However, the appellate court modified the same to simple imprisonment for a period of 6 months with a fine of rupees 5,000. The same does not appear excessive or disproportionate.
Yes, two children.
You are now appealing to the heart of the court. But this is a criminal offense. I have to decide with my mind, not my heart.
My lord. 14 years now, two children.
So one person has lost his life, Mr. Hajorika. How can this court be unmindful of the fact that because of the rash and negligent proof before the two courts, a person has lost his life? Yes, কি লিখিলা? Excessive or disproportionate in the facts and circumstances of the instant case. For the foregoing reasons, this court finds no illegality, impropriety, or perversity in the impugned judgments warranting interference in revisional jurisdiction. The criminal revision petition accordingly stands dismissed. The conviction and sentence of the petitioner under section as recorded by the two courts and modified thereafter by the so-and-so as regards the sentence of so-and-so stands hereby affirmed. The petitioner shall surrender to serve the remaining sentence, if any, return TCR. Sorry, Mr. Hajorika.
Item 10, I was there, let's say.
Right, we shall record your name and say in item 10 due to paucity, huh? And then
Pay for a date, let's say.
when? All right, you did, huh?
item 10.
That's unless.
Suggest a date, both of you together.
Item 12.
Yes.
Lordship, my senior is having.
You want an adjournment? All right, 15 minutes only working time now. So it's all right. When do you want it?
Lordship, last week of November.
Your name?
S. Agarwal, Lordship.
As prayed for by MS.S. Agarwal, Learned Counsel, on the ground that the Learned Senior Counsel leading the brief.
GN Saiban.
No, he has, why is he?
Some personal.
Has some personal difficulty, and noticing that there is only 15 minutes left, and then hence the same is not sufficient for hearing the matter. The matter stands adjourned to such and such date. Did you date? All right.
Okay.